May I please, Your Lordship? Lordship, this writ petition has been filed in the form of public interest litigation, Lordship. Basically, Lordship, in this matter, Lordship, I'm challenging the Section 3 of Artificial Produce Reorganization and District Amendment Act 2024, Lordship. So far as it relates to the district headquarters of Key Panjur district, who is newly created district, Lordship. The district headquarters at Yachuli, Lordship. The facts leading to the filing of this PIL, Lordship, is that, Lordship. Elsewhere, Lordship, there's a district of Lord Shivansi district, Lordship, and it was bifurcated into a 2 district, and Key Panjur district has been created, Lordship, by submitting of the joint memorandum of Lisi Light Society and Tau Supin Dukun, Lordship. That is the organization for the Apatani tribe, Lordship, because that district consists of 2 major tribes. One is Nisi and one is Apatani, Lordship. After the joint memorandum is being submitted to the Deputy Chief, to the Honorable Chief Minister, Lordship, the process has been started, Lordship. The Lordship may kindly come.
They have headquarters. Yes. Is it there after the financial restoration to district water?
You are representing some of the villages.
Villages, Lordship, because
The villages
Lordship,
of the district.
Lordship, it consists of 3
Entire
villages.
district.
I beg your pardon, Lordship.
Entire district.
For the interest of entire district.
You are representing people of the entire district.
For the interest of the public, Lordship.
Forget about interest. Are you representing all of them? Or few handful of people?
Because, Lordship, initially, Lordship,
What is it wrong?
Lordship, initially, the 2 place has been chosen for the district.
Have you read the judgment of this court? Prasanta Kumar.
No, Lordship, I have not gone through with that judgment, Lordship.
You
Only
You must go through the judgment and come back.
my only contention is that, Lordship, since the department, Lordship, has proposed for the 2 place for the district headquarters. One is at present as Yachuli, and another one is Poblit, Lordship, which consists of Pobli, Lichlit, and Nyorpu, Lordship. Now, in spite of the clear direction from the respondent authority, Lordship, the ADC, Additional Deputy Commissioner Yachuli, Lordship, instead of go for the field verification.
Has there any violation of law while choosing the district headquarters?
No, Lordship. So far as, Lordship,
Tomorrow, some other person will say again that it should be here, should be there.
my only contention is, Lordship, since we also want to our district headquarters, wherever it is, Lordship, it has to be developed with a full infrastructure, Lordship. Now, only contention is that, Lordship.
Headquarters will be there only.
Lordship, only contention is that at least field verification has to be done by the authority, Lordship, because since the several representation has been filed, Lordship, and we are since form an organization, Lordship, to apprise the government that the more feasibility area of the district headquarters is Poblit, Lordship, instead of Yachuli, Lordship.
If everyone is starting forming a association for advice to advise the government, what will be the situation?
Lordship, at least the representation may be disposed by the department, Lordship, with the reason, Lordship. That's all, Lordship. Because, Lordship, the present district headquarters, which has been
Yes, Mr. Ratnan, anything to say? We are going
But,
to give notice
whether-
today.
This type of prayers
Yes.
can be entertained by this honorable court, madam. Where the headquarters should be located, where not to be located, how do this court decide? Madam? Whether he has any legal right to claim?
There is a exec on that issue, Takam Sanjay.
Yes, my lord, our
Thank you, then.
own earlier decision,
President
Nilai Sidiso also was there, madam.
Takam Sanjay is also there.
Yes. Nilai Sidiso was earlier.
And Prasanta Kumar.
Yes. Exactly on the point of district headquarters, madam. This was. I'll just read para 6.1. It's a short judgment. Para 6.1. I have heard the learned counsel for the parties at length. The matter of fixation of headquarters is undoubtedly based on the discretion of the government, and the government is in a position to evaluate merits and demerits of a particular place as against other location of headquarters, and the ultimate decision rests on the government in such an area where the discretion is exercised prudently or not. It is the administration which must have the final say. The remedy is to be rendered political than judicially. Because how to do this court decide where should the headquarters be, where not to be?
Yeah, we are
Since-
giving notice, let him
Not-
submit his list. Heard Mr. T. Karam, the learned counsel for the applicant, and also heard Mr. Anderton, the learned additional advocate general. Arunachal Pradesh. This is a PIF filed under Article 226 of the Constitution of India, praying for issuance of writ in nature of randomness and or other appropriate writ, order or direction. Again, and this actually is directed against the impugn action of the respondent authorities, whereby it was decided to build the headquarters of Koi Panior district at Piachpuli. We find it proper to issue notice at this stage. So you are, otherwise you are representing 1, 2, 3,
All the
all
rest.
this. However, Mr. Anderton, learned advocate general has already, additional advocate general has already appeared for respondent number 1, 2, and 3. Full stop, no formal notice is required to be served. However, the extra copy of the petition may be served to the respondent side during the course of the day. List the matter accordingly. You want any time further?
No, also after 3 weeks, lots.
After
after 4
3
weeks.
weeks.
After
After 4 weeks.
4 weeks.
List after 4 weeks. Otherwise, they do.
You filed a
Same.
response, maintainability also you
Yes,
raised.
ma'am.
Yes.
You may raise it.
We otherwise will reflect in the order if you raise the maintainability issue.
Yes, ma'am.
Mr. Rotten, this so and so has also raised the maintainability issue on the next date of listing. The matter may be heard on the maintainability.
Deeply obliged.
Always, ma'am.
Item number 2. It was fixed, no? Item number 2 was fixed. Yes, on the last provision, we have, in fact,
Yes, Lordship.
used as an amicus.
Lordship, I had a talk with the petitioner last night.
Huh.
And as per his version, the file is also at Guwahati. So some time may be given to him. That's what he prayed.
Otherwise, just my brother has also pointed out that there's a,
No,
in fact, is it a case of,
yes.
by
Otherwise,
the,
government has already executed. They have already executed the work. So that part is there. But since the petitioner was saying that I have prepared what he said is we have filed an affidavit also in reply.
affidavit in reply,
Yes,
you are going to submit. But the petitioner is going to submit,
petitioner has filed.
already filed.
That's what he said. Lordship. I have not checked the records. I have not checked. So
Yes, then.
No, we have not received any affidavit in reply. He was supposed to
let's-
file, whether it has been filed or not.
He also has, I think, my,
on my
as per
part,
the office note, last office note is of 10/6/2024, reason the affidavit is not yet filed. As per the office note, but if we have this such kind of instruction that it has already been filed, but the copy is not, you have not.
No, we have not received any copy.
Oh, this is PL petition. As per this one.
Yeah.
Uh,
There is no record in the, there is no rejoinder affidavit in the record.
I have no idea, Lordship.
Otherwise, it cannot be a PI.
Yes.
Challenging the tender on the ground that it was not widely published.
More so as per the affidavit of the government, they have already executed.
Okay.
Inauguration also has been done. That is it.
If you want. Heard Mr. Yapang, the learned senior advocate. Learned senior advocate who is appointed as an American student last occasion. Also heard Mr. Andrew, the learned additional advocate general of AP, appearing on behalf of state respondent, and Mr. T. Garam, the learned counsel appearing on behalf of the respondent number 5. It is submitted by Mr. Yapang, the learned senior counsel, that as per instructions received from the petitioner, they have already filed the rejoinder affidavit. However, from the office note dated 10/6/2022, it is seen that the rejoinder affidavit is not yet filed by the petitioner. In that context, Mr. Apam submitted that how many weeks you need otherwise?
After 1 week,
After 1 week, we'll do. Okay, after 1 week, maybe. No, if they have already filed or if they are preparing that, take 2 weeks. Otherwise, I don't know.
Lordship,
1 week. 1 week will do.
I'll call him and
Oh.
convey that instruction.
Considering the prayer made by this, made by the learned council for the learned amicus duty, let the matter be listed after 1 week. Okay.
Also, that may be the last chance. Otherwise, Lordship, this PI is nothing but the vesting.
Yes, sir.
You call him and say that it's not maintainable. It cannot be a PI. Where
I am with the court's view.
In fact,
let him be ready with the cost.
yes, Madam. In fact, such a busybody
part-
petitioner.
That part, that part,
You're not going to say that part
I have second thought.
Okay.
If you.
after 1 week. Paper book is already ready.
Yes, your paper book ready and service has been completed, your lordship. The notice was issued to the victim on the earlier occasion. This is for the second time this matter is come before your lordship. On the very first day, the notice was issued. There are direction for preparation of paper book, and paper book has been prepared, and we have received the paper book as well, your lordship. So now this matter may be fixed for a final hearing, your lordship.
Otherwise, also it is a case of 302.
Yes, your lordship.
He is in jail.
I'm the LEC of the
No, no.
convicted person.
Jail mein.
My lord, if possible, make after 4 weeks. Very recently, I received the paper book and other material, so I take time for the preparation.
Takes 4 weeks
4 weeks, my
to
lord.
prepare the case.
Yes, my lord. After 4 weeks.
So you're legal aid counsel, no?
Yes, I am the LEC counsel, yes, legal counsel.
And heard Mr. M. Bagara, the learned legal aid counsel, appearing on behalf of the appellant, and also heard Mr. T. Eti, the learned additional PP, appearing on behalf of the respondent. It is submitted by Mr. Eti that the learned additional PP that the service is already completed in the respond number 2, and the paper will is also ready. So matter may be listed for final hearing accordingly. List accordingly after 4 weeks?
Yes, my
After
lord.
4 weeks.
After 4 weeks.
List accordingly. For in hearing column.
Obliged.
Much obliged.
My lord, appellants are Jila Parishad members. They are 4 in numbers. The term of appellant number 1, 3, and 4 will be over in December 2025. Whereas of appellant number 2, his term will be over in October 2028. Now, my lord, it is their disqualification which is under challenge in the present appeal. The order of disqualification was challenged before the learned single judge.
Why 2028?
Because, my lord, in the case of appellant 2, he was declared elected in October 2023. So 5 years period, my lord, under section 86 of the Panchayati Raj Act. In the case of the other 3, they were declared elected in December 2021. That's the reasons. In December 2020. So the period of 5 years under the Panchayati Raj Act. That is the term. Now, my lord, I'll just take your lordship to the relevant documents. Thereafter, I'll build up my case as to the grounds on which I am assailing the order of learned single judge. Now, my lord will turn to the page 65 of the paper book. Page 65. The typed copy is page 66, but page 65 is also legible. This is the notification, my lord, of 27th February, carving out a new district, K. Penyor, from the erstwhile undivided Lower Subansiri district. So far as, my lord, the constituencies of these 4 Jilla Parishad members are concerned, their constituencies fell under the newly carved out K. Penyor district. So their constituencies being part of the new district, K. Penyor, they toyed with the idea because they were elected on the BJP ticket. They became Jilla Parishad member on the BJP ticket. So they toyed with the idea of joining Ajit Pawar group, NCP Ajit Pawar. Because once their constituencies are part of the new district, obviously, my lord, they'll be constituting 2/3 majority over there, or more than the 2/3. So there was this idea of merger with NCP Ajit Pawar. This is the trigger. Now, my lord, will turn to the page 67. That is how things started. It developed. On 28th of March 2024, these 4 appellants, the first letter is addressed to District President of the Bharatiya Janata Party of K. Penyor district, stating that the typed copy, my lord, will get in page 68. It is to respectfully inform and bring to your notice that we, the undersigned, 5 Jilla Parishad members, the one was independent. He joined hand, including the present JPC, out of the total 6 ZPMs of K. Penyor district Jilla Parishad do hereby merge to NCP Ajit Pawar with more than 2/3 majority. My submission would be, my lord, though there is a declaration of merger, but declaration of merger can never be complete. It can't be fructified unless and until the other party acknowledges it. So it is an expression of intent, regardless of the language used. Because merely because they say there is a merger, merger would not be effective. There is an expression of intent of merger. Page 68. Now, thereafter, page 70. This is show cause notice. This I will read. Immediately after this expression of intent of merger, now, my lord, there is additional submission I am making. Apart from the expression of intention of merger, simultaneously they also submitted the resignation from the BJP. Otherwise, there can't be merger. Resignation was never accepted. Show cause comes, page 70. My lord will see the show cause from the Bharatiya Janata Party. This is with reference to written complaint and representation received by the party office about your alleged misconduct, non-adherence and non-compliance to the direction, notification and circular issued in interest of the party. Furthermore, allegations that you are indulging in anti-party activities for your self-vested interest. Our party believes in such and such, such and such. So the last paragraph now is, you are hereby directed to submit written explanation of your conduct within a period of 7 days. So the show cause notice, it doesn't talk about their merger, resignation, etc. It is in connection with their anti-party activities. They never receive it. It is the case, be that as it may, the expulsion order is issued on 7th of April 2024. The expulsion orders in all the 4 cases are verbatim similar. I will just read one. Page 71. Undersigned issued a show cause notice to such and such, white number such and such, dated 29th March 24, to put forth an explanation to the party for breaching of the party constitution by indulging in anti-party activities and non-compliance of state office directions, party whip with the direction that she may submit an explanation within a period of 7 days from the date of receipt of the notice. And whereas the undersigned has not received any reply, from her till date, which is unjustified, unsatisfactory, and lame excuse on her part, and thereby clearly breaching party discipline, thereby violating articles such and such of the Constitution of Bharatiya Janata Party, which ultimately will affect the smooth functioning of party organization in the ensuing general election and assembly election such and such. Therefore, in exercise of the power under the Party Disciplinary Act such and such is hereby expelled from Bharatiya Janata Party for a period of 6 years from the date of this expulsion order. Further, her primary member, active member, and such as the responsibility such and such. So, my lord, expulsion order, expulsion from the primary membership of the party for a period of 6 years in all the 4 cases. Expulsion comes after expulsion. Page 75, my lord will find the chairman, State Disciplinary Action Committee of the BJP, page 75, addresses a communication to the member secretary of the Jilla Parishad of the undivided lower Subhansiri. The relevant paragraphs are at page 76. The relevant portion I will read. The expelled members, the second paragraph of page 76. The expelled members have not submitted any letter or intimation regarding any withdrawal of merger to NCP Ajit Pawar, either before the office of the district president of the concerned district, nor before the chairman, SDAC, BJP, or Arunachal Pradesh till date. It is made absolutely clear that there is no revocation order in respect to the expulsion made against the said expelled members on such and such, nor any pending proceeding for consideration of revocation before the State Disciplinary Action Committee as on party records till date. Therefore, it is reiterated that the expulsion order dated 7/4/24 stands and the expelled members are no longer members of BJP. Their disqualification should be a watermark example against unethical practice of politics in the state of Arunachal Pradesh. It must serve as a stern warning across all party lines that law of the land shall not allow trampling of the cherished democratic process. Your kind chair is prayed to immediately disqualify the defectors under relevant provisions of Arunachal Pradesh Local Authorities Prohibition or Defection Act 2003, amended in 2006. Therefore, all the members must be disqualified immediately without any delay, and the concerned Jilla constituencies may be declared vacant henceforth. Any delay in disqualification of the above expelled members shall be regretted and viewed as murder of democracy such and such. So, my lord, it is evident the trigger is their expulsion from the BJP. So far as expulsion from the BJP is concerned, though the order of expulsion doesn't talk about the merger, it talks about the anti-party activities, but I would presume that the trigger was the expression of intent of merger, followed by expulsion, and expulsion was the trigger so far as initiation of disqualification proceeding is concerned. Expulsion being the sole basis. Then my lord will find the next page, the page 79. Page 79. This is the Deputy Commissioner. He issues show cause notice dated 10th April 2024 to all the 4 Jilla Parishad members. Whereas, by letter number nil dated such and such addressed to Deputy Commissioner, you had intimated that 4 Bharatiya Janata Party ZPMs and 1 independent ZPM, total 5 out of 6 ZPM of KPN or district, do hereby merge to NCP Ajit Pawar with more than 2/3 majority. And whereas the state president in charge, come chairman State Disciplinary Action Committee, BJP of Arunachal Pradesh, while letter number such and such, dated such and such, had intimated regarding your expulsion from Bharatiya Janata Party and prayed for disqualification thereof under relevant laws. In view of the above facts and circumstances, you are hereby directed to show cause as to why action should not be initiated against you under Section 3, read with Section 4, 5, and 6 of the Arunachal Pradesh Local Authorities Prohibition or Defection Act. In this regard, you are hereby required to be present in person, such and such, such and such. So, my lord, show cause notice makes it evident that there are two factors that have been considered in the show cause notice, namely, number one, their merger with the NCP Ajit Pawar. This is what the Deputy Commissioner says is learned. And number two, the complaint of the BJP and their expulsion. Primarily, my lord, it is the expulsion which is the sole basis of the show cause notice yet again. Now comes the page 81. On 10th of April, show cause notice issued, initiating disqualification proceeding. 6 days later, on 16th of April 2024, they withdraw the resignation from the primary membership of the BJP. They say we are not, we are with the BJP only. We are withdrawing our resignation, page 81. We, the undersigned, 4th Jilla Parishad member of K. Pennaur district has resigned on 28th March 24 from the primary membership of BJP in protest. Now we have decided to withdraw our resignation and will remain in the party. We have been informed that Young and People's Honorable such and such Pema Khanduji have appealed to the PRI leaders to come back to the party in a recently held party meeting at Yazali. On 4th of April, my lord, there was a party meeting at Yazali. The Chief Minister gave a call and they say in connection with that very particular call, we are withdrawing our resignation, we are coming back to the BJP. That is 16th April. The second communication is also addressed to the district president again of the same date, 16th of April. Here they talk about the rejoining the BJP. So these are the two communications. Now, my lord, thereafter, my lord will find the moment they withdraw their resignation, they talk about rejoining the BJP, they speak about the call of the Chief Minister, the BJP gets worried, lest it influences the disqualification proceeding. So the letter is written to the Deputy Commissioner by the BJP. It is at page 83, 23rd of April, 24. The second paragraph of the letter is relevant at page 83. This I read. The State Disciplinary Action Committee has been apprised by the District President BJP, Unit Lower Subansiri K. Pennaur, that amidst the pendency of disqualification proceeding, that is amidst the pendency of disqualification proceeding against them, the above mentioned expelled members are now reportedly claiming that they had recalled their merger to NCP Ajit Pawar. It appears that they are claiming that they have made an ethical decision to respond to the clarion call of Honorable Chief Minister to all misguided PRIs to return to the party fold on or before 17th April 24 before 17 hours. That was the deadline, 17th of April. It is to apprise your kind office that Bharatiya Janata Party of Arunachal Pradesh strongly prays for disqualification of the above members. The claims of withdrawal of merger to NCP Ajit Pawar of the expelled members are nothing but calculated afterthought claims made in order to escape from the consequences of expulsion and disqualification. So the party informs the Deputy Commissioner that their talk of rejoining the party, their talk of withdrawing the resignation is nothing but an afterthought. It's a calculated game, primarily for the purpose of escaping from the consequences of expulsion and the likely disqualification. They give a reply to the show cause at page 85. I would not trouble your lordship, except I will read one paragraph at page 87, the reply of the appellants. Page 87, relevant paragraph 5 and 6. I read paragraph 5 at page 87, that we beg to inform you that NCP Ajit Pawar has not accepted our merger, letter dated 28th March 24, addressed to your good office. The merger application was submitted under misconception regarding the notification of newly created district K. Pennaur. Also, the merger was under the impression that creation of new district would naturally entail new PRI connoting 2/3 majority in such predicament, since our merger has not been accepted by the NCP Ajit Pawar and no formal joining was completed. Also, undersigned has made an ethical decision to uphold the sanctity of the appeal made by young and dynamic Honorable Chief Minister Shri Pema Khandu ji on 4th of April 24 to all the misguided PRIs to return to the party fold on or before 17th April 24 before 17 hours. Accordingly, the undersigned 4 PMs has already recalled and withdrawn the merger application dated 28th March 24, submitted to your good office dated 16th April 24, and also withdrawn the resignation from primary membership of BJP. And same has been sent through mail and registered post to your good office. Also, we have rejoined the BJP on 16th April 24, and same has been acknowledged to the party office in K. Penor district. But due to absence of president and other party workers, we could not obtain proper recess of our rejoining in the party. That we beg to state that on appeal made by Honorable Chief Minister, we have not indulged any party activities against BJP MLA candidate in 16 Yachuli, such and such. Hence, there is no question of entailing disqualification against us, etc., etc. So the sum and substance is, look, we paid a heed to the call of the Honorable Chief Minister and we withdrew our resignation and we have joined the party. They have also stated that because of certain misconception, they had tried to go for the merger, but the merger was never complete. So this is it. Now, my lord, finally, the order of disqualification was issued. It is 14th of May 2024. The relevant page is page 89. 89 to 96. The relevant page that I will refer to are pages 95 and 96. Lordship may see the findings at page 95. Because otherwise submissions of the lawyers, the law on the subject, etc., findings are relevant. Page 95. It is neither denied nor refuted that 4 Jila Parishad members voluntarily tried to merge with NCP Ajit Pawar under the misconception that the bifurcation of the district of Lower Subansiri into Lower Subansiri and K. Penor district, the Jila Parishad also stands bifurcated, and that they form more than 2/3 of the elected member of Jila Parishad for K. Penor. It is pertinent to mention here that the Jila Parishad of undivided Lower Subansiri district has 20 members, out of which 14 members belong to 01 block, that is Lower Subansiri, and 6 belong to 02 block, now K. Penor. So, my lord, one thing is evident: in the event of constitution of a formal Jila Parishad for K. Penor district, certainly these persons would have constituted more than 2/3, because 6 belong to the newly constituted K. Penor. The matter regarding bifurcation of Jila Parishad of undivided Lower Subansiri district was referred to State Election Commission, who, while WT message such and such, replied that the Jila Parishad has not been yet constituted in respect of K. Penor district. That subsequent to the merger attempts made by the 4 Jila Parishad members, while their letter dated 28th of March 24, the BJP expelled the said members, while their expulsion order dated 7th April 24, and that the request of the 4 Jila Parishad members to rejoin the party while withdrawing the resignation has not been considered by the Disciplinary Action Committee BJP or Arunachal Pradesh. On the question regarding whether the disqualification matter can be instituted and orders be issued, while the model code of conduct being enforced, such and such, the matter was referred to Chief Election Commissioner, but that's not relevant. They said, no, regardless of the model code of conduct, we can pass an order. There's no quarrel with that. So, my lord, what is relevant is, from the findings, it is evident. What are the factors considered by the Deputy Commissioner? Number 1, attempt to merger. Number 2, expulsion by the BJP. Number 3, their withdrawal of the resignation not considered by the BJP. Again, I repeat, my lord, number 1, merger attempts. Number 2, consequential expulsion by the BJP. And number 3, withdrawal of resignation not considered by the BJP. These were the 3 factors. Now, my lord, in a writ petition, this order was essayed. And before that, I'll just show one more thing, my lord, at page 98. Now, the process to constitute new Jila Parishad for K. Penno district has been initiated on 21st May 24, that is page 98 of the paper book. The process has been started for constitution of a new Jila Parishad. The moment Jila Parishad comes, they will be 2/3 or more. Now, my lord, this was essayed before the learned single judge, and so far as the findings of learned single judge are concerned, that I will refer to. My lord will find paragraph 17 first, page 32.
Yes, Mr. Is it for disposal today?
My lord,
I think
because
notice,
I'll press for stay because otherwise, my lord,
No,
if
notice,
Jila
notice,
Parishad is constituted, and my lord, because my lord, at least some
I
interim
think
protection-
notice has to go.
Mr. Caveat is there, Mr. Mazumdar is appearing
For what? For whom?
for the BJP. My lord, he's for the ruling party always.
State president.
Mr. Mazumdar is for the ruling party. I am for the have-nots, the downtrodden.
Then election commission?
Election Commission, Mr. Ajit, Mr. Ajit Apang, I believe should be. Yeah. I don't know. Seems that he made a hasty retreat.
For two, who is appearing? Respond number two.
I beg your pardon, my lord.
Respond number two, election commission, who is appearing?
Election Commission, my lord, actually after the 2006 amendment, though Election Commission has been made a formal party, but after 2006 amendment, State Election Commission, the word used in the Prohibition of Defection Act, it means Deputy Commissioner. And Deputy Commissioner is very much a party here. So to that extent, my lord, the role of Election Commission is very, very hardly any, in fact. They are more a formal party. So it is the BJP which is.
Mr. Mujumdar, so you are appearing for three, I think. You are for BJP.
Respond number 3, mine.
Yes, yes.
Lordship,
He will, my lord, oppose me tooth and nail. So therefore, better I place my grounds on which I am assailing.
First of all, even before the one single judgment, the matter was taken up on the first day. I made at the conclusion of my submissions, I made a submission that this is not a case for even admission. My lord, the real issue is nothing. This resignation, merger, etc. Nothing.
My lord, then I'll make my,
Yes,
better I make my
I'm just
submission.
indicating, I'll argue. The real issue is whether, in terms of the Act of 2003, my lord, they have voluntarily given up their membership. Honorable Supreme Court, in the case of Vishwanathan and the other case referred, it has been made clear that it can be either implied or expressed, or by conduct, if it is found that you have voluntarily given up the membership of the political party on whose ticket you have been elected.
so we're asking whether this is for disposal. Can we dispose it of today? Can you complete?
But then for issuance of
My lord,
notice
if I-
also, my lord, I'm just indicating one thing. For issuance of notice also, my lord, in the impugned judgment of the Honorable Single Judge Lordship finding, the last paragraph, it has been indicated, the state government is not a party. So on that view of the matter, whether the written notice can be issued at this Lordship, kindly have a look at this page 35, my lord.
State government
Before
is not
parting with
only.
the records, we put it on record that it is noted the state of Arunachal Pradesh as well as concerned political party have not been arrayed as respondents. So in that way, the matter, even the writ petition itself is not maintainable on this count. Writ appeal is also not maintainable without
I'll
making
argue
the
on
state
that.
government, without making the political party against whose objection you have come. You are agreed by the decision of the political party to disqualify you, and then the decision was taken to
Let
disqualify.
me-
Let them amend the petition,
Let
then your lordship will issue notice.
it is
Or
not,
otherwise, my lord, your
that
lordship
was the
can,
point, sir.
yes, lordship may issue notice, and then the maintainability question may be kept open. And there is no question of stay, my lord. Otherwise, in this case, If his interim order is granted, it will amount to allowing the whole writ appeal on the first day, whereas the writ petition was dismissed. So if
My
you
lord, may I?
have to issue notice.
Sir, please. May I? Otherwise, let me make my grounds. The grounds,
Let us do one thing. If you are ready, we'll hear it today. We'll
my lord, I
complete it.
finish it because my lord, otherwise Jilla Parishad is being constituted. Once the Jilla Parishad is constituted, they will go
Are
for
you-
election.
Are you ready?
I'm ready.
Same here, my lord. Yes, my lord. So now, lordship, I'll come to. Page 30,
Election Commission ready? Are you ready?
he's always ready, my lord. He's always ready.
Without any paper.
We'll give you a copy. They hardly have any role, my lord. Primarily is the BJP, namely the disciplinary authority. It is the president who is the party because he initiated the entire process. He is the competent authority. The BJP per se has no role. It is not the chief minister we are against. We heeded the advice of the chief minister and we came to the party fold. I'll address on those issues, on maintainability also. So, my lord, I'm coming to the impugned order of learned single judge. Page 35 of the paper book. Sorry, page 32 to begin with. Page 32 of the paper book. This is the part of the impugned order of learned single judge. The impugned order begins from page 26.
Yes, Mr. Navam, you want to say?
Lordship, if we have to be in a party, may I pray that some 1 or 2 days may be given, or maybe maybe taken up tomorrow, so that at least
Tomorrow, it's not possible. In that case, it will be on the either Monday or Tuesday.
Election Commission has no role. Our grievances with the disciplinary authority, who is the president of the BJP, is
Why you have made them party then?
that's formal, informal, whatever. The pro forma, they hardly have any role. Primarily, the principal grievances between Mr. Mazumdar and I myself. Mr. Mazumdar representing the president, state in charge BJP. He is all in all. He is above the chief minister. Because we bowed before the chief minister, but Mr. Mazumdar's client is not happy with us. Therein lies the whole problem. So, well, anyway,
If Mr. Apang, if you are suppose not ready, just my brother is suggesting that can it be fixed on next Tuesday? Because Tuesday is a division bench we are fixing.
my lord, I have my
By Tuesday.
difficulty. My lord, I have got a partner matter fixed before the principal seat.
My submission, Lordship may kindly consider. This is not a case for stay. If your Lordship's desire to issue notice may be issued on a date. All the parties will argue or final on merit. It's not a case for stay, madam. They are already out since long back.
Mr. Mazumdar
Writ
feels it
petition
is,
has been dismissed. Now they have filed a writ appeal. If your Lordship
there are
decides
hundreds of
consider-
cases, there are hundreds
your
of
lordship-
cases where the
your lordship-
petitions are dismissed
if
and
your-
the stays are given
if your
by
lordship-
division bench.
if your
What's the big deal about it?
if your Lordships again desire to examine the validity of the order passed by the Honorable Single Judge, Lordship may do it. But my humble submission will be, first of all, it's not maintainable. Maintainability question may be kept open. Matter may be fixed on a date when all the parties will know that it will be taken up for disposal. It can be disposed of on it.
No, maintainability, have you raised it before the learned single judge?
My lord,
That will
Honorable
continue.
Single Judge- Honorable
It was
Single
never
Judge-
raised.
This is
Issue of maintainability
inter
was never raised.
intercourt appeal was the question of, are you saying that it's a writ petition, writ appeal is not maintainable?
No, if the writ petition itself is indicated
Yes.
clearly in the order.
We don't have to,
In
you
view
may,
of-
There's no
you may
indication like
argue
that.
that
Well, I'll argue that. I'm only saying that. in view of
maintainability
this-
is a question of law. It's always open for.
If the writ petition is maintainable, writ appeal
So
has
if-
to be maintainable.
Yes, in that case,
And
if
maintainability
we-
issue was not raised before learned single judge.
otherwise it's a writ appeal, unless you say that the writ appeal is not maintainable. It's the question of, I mean,
I am representing a authority. Without having any paper, I have no say in the matter. If I'm not given the paper, my name may not be reflected and I'll be
My
behind.
lord, my submission is like this. I'll try to prima facie.
At least give me a copy.
Please. Since there is no caveat by the election commission, prima facie, I will try to satisfy my lords that there is a case for interim order, interim protection here. If I fail to persuade my lord, writ appeal gets dismissed. If I can persuade your lordship, it's a case for interim protection, then certainly Mr. Apang will get the opportunity on the final, on the day of the final hearing.
Passing any order on stay, let the matter be finally
Yes,
heard,
yes,
entire matter be
yes,
heard on
yes.
Tuesday, either
In the
or
meantime,
at, or in your convenient date. If you have be.
Lord, may I put it this way? In
Wednesday
the
or
process of the constitution of the new Jilla Parishad has already begun. Lordship has seen the page 98 of the paper book. It was also part of the writ petition. If the new Jilla Parishad is constituted, they are the part of the new Jilla Parishad. They constitute more than 2/3. Automatically, they get the legal protection of merger.
These submissions will not have any bearing on the validity of the judgment. I am humbly submitting.
So that's why at
It
least
is
let me-
something made just to impress upon the court. This has got nothing to do with the creation of new district has not been created. Once it is created, it will have its members. If there are disqualified members, there will be fresh election.
By that I mean to say, if the seats are vacant, there would be election. Then the entire thing.
For that, you have
then-
to file a fresh writ petition. This issue is not there, my lord.
Of course, because my
It
term
is not,
contain,
no,
it's, sir, like a football match,
It
you
is
can't
not a-
argue.
my lord, it is not. a
It's not
subject-
like a rally here, rally
it is
there.
Not a subject matter of this.
If it's,
In fact, short issue, which needs to be considered is only whether the conduct
Yes.
yes, I am on that.
appellant.
I'm addressing your lordship on that.
Absolutely.
it amounts to voluntary
Absolutely,
giving
sir,
up
I
the
know that.
membership. That's all.
I'm arguing only on that point. But for that, I have to show the flaw in the observations made by the learned single judge.
All the
Sir,
Supreme Court
Mr.
judgments
Gupta
are,
had to be grievous
my
there.
lord, all the Supreme
Sir,
Court
this is not-
judgments are against this submission. That your conduct is sufficient to show that you have given up your wages.
I can
That
argue
is
to
the
the
ground-
contrary judgments are
My lord,
against.
that is
Mr.
the ground
Gupta.
on which the writ petition has been dismissed.
So like this, I can't argue, like in continuous interruptions.
Why just interacting? We're yet to proceed.
I'm showing the flaw in the observations made by the learned single judge. Thereafter, I will address the core issue before this honorable court. Namely, my conduct, I will address on that.
No,
Lordship may
they-
see
they,
page-
we are not hearing, I mean, we are not going.
My lord,
to
I'm
pass
not
any
on the-
order on stay.
My
But
lord,
the
I'm
question
not-
is that.
I'm addressing the lordship, my lord.
So let us fix a date on. If
My
you are
lord,
busy on
even to
Tuesday,
argue on
we are
stay.
Thursday.
Lordship, may kindly, my lord, even if I make a prayer for a stay, I have to prima facie satisfy your lordship. I'm addressing my lord on the prima facie satisfaction of the writ appeal. Do I have a case or not? Lordship may examine it. On that I am addressing. I'm not going into the thick of it. So, my lord, kindly, 2-3 paragraphs of learned single judge. I am on paragraph 17, page 32. Para 17, page 32.
In that case, we are hearing only for the purpose of consideration of interim prayer.
Yes,
We'll issue notice, we'll consider, we'll hear you on the interim.
interim, my lord. I'm
Yes.
only on interim, I'm
Yes.
asking. Para 17, page 32. Page
Yes.
32, para 17. Once the petitioners have resigned, it was not obligatory on part of the concerned political party to communicate to the petitioners. I'm sorry, page 32, para 17. That's the part of the order of the learned single judge. Once the petitioners have resigned, it was not obligatory on part of the concerned political party to communicate to the petitioners as to whether the resignation was accepted or not. Pausing here, my lord, for a moment. On 28th March, if I resigned, and learned single judge says it is not obligatory for them to accept a resignation because you have resigned. Accepted. Then from where does the expulsion come? A person who is no longer the member of the party, can he be expelled from the party? I ask myself. Herein lies the first inherent flaw in the order of the learned single judge. If I resign, the relationship gets break down completely. Then what for you begin the process of expulsion from the party? From the primary membership. Membership is no longer there. There is a severance of relationship. Herein lies the first flaw. I proceed further. it is seen that the respondent number 3 had not only issued 4 separate expulsion order dated 7th of April 24, so much later. That means they did not accept my resignation. Since BJP did not accept my resignation, BJP chose to expel me from the party. So, my lord, since BJP did not accept my resignation, BJP chose to expel me from the party. So it is the expulsion which was the basis of my removal from the party.
No, not only expulsion.
Yes. So I am on the expulsion. So therefore, my lord, now straight away let us come. So far as London single judge is concerned, there is inherent fallacy. Then London single judge says that my withdrawal of resignation is an afterthought. No, my lord, I say I have paid heed to the call of the Honorable the Chief Minister. My lord, para 19, page 33. The petitioner's walled face. Para 19, page 33. The petitioner's walled face after the merger did not materialize clearly depicts that the plea of withdrawing resignation and expression of interest to rejoin the party of respondent 3 is an afterthought. My lord, pausing here, I submit, this is the phraseology London single judge has taken from the letter of the state in charge of the BJP. Even the deputy commissioner has not used such an expression. Deputy commissioner doesn't talk about the afterthought. Chief minister makes a call. I paid a heed to the call. There is the question of an afterthought. And then the Mohinder Singh guilt principles comes in, my lord Justice Ete would appreciate the fact that something which is not has been spoken by the deputy commissioner can't be added by the London single judge. It's absolutely subjective, whether it is an afterthought or not. Rejoin the party of respondent 3 is an afterthought. The petitioners having written to the concerned political party that they were withdrawing resignation and their expression of intention to rejoin the said political party cannot undo the cause of action that had already accrued for the respondent number 1 to examine the disqualification after the process initiated by respondent number 3 was not recalled such and such. My lord, now I'll straight away address my lord on the core issues. Some of the judgments have been referred. I will deal with the judgments. Now, my lord, my basic submission is this. Lordship has seen from this. Number 1, expulsion was the sole basis of initiation of disqualification proceeding. Number 1. Now, number 2, whether expulsion can be the sole basis is an issue for examination. Lordship knows the G. Vishwanathan principle. In G. Vishwanathan, the Supreme Court said, I will refer to that very paragraph, that expulsion can be the sole basis because once you are elected on the ticket of a political party and you are out of that political party, then certainly you can be, it would be treated that as if you have voluntarily resigned from the party. So expulsion can be the basis. But my lord, in the Amar Singh case, this I will refer. In the Amar Singh case, 2011, 1 SCC 210. 2011, volume 1, SCC 210. The entire paragraph of G. Vishwanathan, the Supreme Court doubted the correctness of that paragraph in Amar Singh. Para 17 and para 18, relevant page 210, Lordship may see. Yes. 210 judgment begins and the relevant paragraph is para 17 and para 18. Para 17, my lord, I read at page 215. Page 215. We are also convinced that the decision in G. Vishwanathan case merits another look as far as the members of the House who are expelled from their parties on whose banner they had been elected to the House are concerned, as they would be left completely vulnerable to the whims and fancies of the leaders of their parties. We therefore issue rule in the 2 writ petitions and request the Honorable the Chief Justice of India to refer the matter to a larger bench on the following questions. Questions were framed, Lordship may see, question number 6. Total 7 questions were framed, the question number 6. When a member of either House of Parliament is expelled by the party which had set him up as a candidate for election and he either joins another political party or forms his own party, can it be said that he had voluntarily given up his membership of the party in view of the legal fiction created by explanation A to para 2 sub para 1 of the 10th schedule? So this was an issue Then para 18, pending the reference, the decision in G. Vishwanathan case shall not be applied to the two writ petitioners, Shri Amar Singh and Ms. Jayaprada. So, my lord, this was put on hold. Then what happened? I come to Amar Singh 2. Then I come to Amar Singh 2. Amar Singh 2, my lord, will find 2017. Volume 13 SEC, page 222. The relevant para it starts from page 222. Para 7, 8, 9, and 10. Let me just give some summary. What happened was, in Amar Singh Lordship has noted, in Amar Singh 1, the matter was referred to larger bench. G. Vishwanathan observation was put on hold in respect of the two writ petitioners. Now, 3 years later, my lord, the case was heard by the Supreme Court. And by that time, the membership, Mr. Amar Singh had completed his tenure. So, since he had completed his tenure, the Supreme Court said it is of academic interest only. So, the issue was not decided. Mr. Amar Singh became member again. Once he became member again, the similar situation arose. Then the Amar Singh 2 came. In Amar Singh 2, the Supreme Court revived the old question. My lord will get it. In paragraph 7, page 227, Amar Singh 2. Para 7, the observation is in connection with the question referred to a larger bench. What happened? The matter was heard by a 3-judge bench, which reserved the matter but eventually passed the following order on 3/8/2016. The petitioners who were members of the Rajya Sabha at the relevant point of time have completed their tenure in the meantime. In the above situation, though we have heard the matter at length and had reserved the judgment, we are of the view that it would be more appropriate not to answer any of the issues referred to this larger bench by a 2-judge bench of this court. We therefore decline to answer the question referred. So the question was not answered. Once, my lord, once again the issue was raised, then the Supreme Court said, para 8. As we find in the case at hand, the term of the petitioner shall be up to 4/7/22. Thus, the reference that was made in Amar Singh, that is Amar Singh 1, the present petitioners remains to be dealt with, as the same has not been answered with the flux of time. As the question remains alive today, we think it appropriate that the matter should be placed before the larger bench for consideration of the questions which we have reproduced from the decision rendered in Amar Singh. Then such and such senior counsel appearing for the petitioner prayed for interim relief in terms of para 18 of the decision rendered in Amar Singh. The said paragraph read as follows: pending the reference, the decision in G. Vishwanathan case shall not be applied to the two writ petitioner, such and such, such and such. Keeping that in view, we issue notice to the respondents on the interim relief. Let the papers be placed. Honorable the Chief Justice of India for constitution of appropriate larger bench. Subsequently, below the order is there, not reported. It was again, protection was given of the interim order. So, issue continues and matter is pending reference of the larger bench. Now, my lord, I'll come to the core issue. The conduct. Expression used is section 3(1)(a). Lord Chief will see the Prohibition of Defection Act. Prohibition of Defection Act, section 3, subsection 1(a), subject to the provision of section 4, 5, and 6. I'm sorry. My endeavor would be to demonstrate before your lordship, when we talk about the conduct, conduct is a sum total of numerous actions. Conduct may be, one action may be a conduct, but when one action gets neutralized by another action, and there are various actions within a short duration of time, the conduct has to be seen in a cohesive manner. Holistically, the conduct has to be seen. Expression of intent of merger. I resign. 10 days later, I said, no, I don't want to resign. I'll go back to my parent party. Parent party has only expelled me. Parent party never accepted my resignation. So the entire chain of actions. Could it be said that I have resigned from the party? Earlier resignation never accepted. You expel me from the party. So expulsion is the basis. When expulsion is the basis, then certainly you cannot throw me out of the party like this. My seat cannot be treated to be vacant. Voluntary, Lordship will see the expression, section 3, subsection 1. Subject to the provision of section, I'm sorry. My Lord Justice, it possibly doesn't. Do I have the extra? If I have the extra copy, I'll give it to my Lord. No, it is not. Mr. Mazumdar?
No, Mr. Tiwari, yes, Mr. Nawam have raised some accommodation for him.
Milord,
So
at least-
you are going to argue the entire case. You
No,
are
no,
arguing the entire
interim,
case.
interim relief.
Come for this day.
I'm interim relief only,
Why do you
interim
need stay?
protection, interim protection. Because seats have been treated to be vacant.
Tomorrow.
Tomorrow-
Arguing on merit, if interim or in by way of this interim consideration of interim prayer, if the entire case is decided, what will be left?
Yes.
Then fine, let it be decided either way. Because if I don't
Yeah,
get the interim
that's
relief,
why I'm
my
saying
lord,
that if
if
you're
I
on
don't
interim
get the
prayer,
interim
then
My
relief,
you
I'm
are
out.
sufficient of
my lords
interim
have
prayer.
already indicated that your lordships are hearing only for interim.
Mr.
Now he is
Mazumdar,
arguing the case on merit.
if Mr. Mazumdar is having such a good case, why is he perturbed? Let me project my case. Why are you worried, sir?
Thing is different thing, but you are praying for the interim only.
Yeah, only interim only, my
Come,
lord.
come to the interim prayer only.
So I'm coming to the interim
You are
prayer.
the entirely.
Prima facie, my lord, why? Because to show the interim, my lord, I have to show the law. The term is, if he has voluntarily given up his membership of such political party, I ask myself, where have I given up the membership? I resign, you don't accept the resignation, you expel. I withdraw my resignation, I rejoin the party. You don't accept it, then only expulsion remains. If only expulsion remains, my submission is the principle of amercing would come into play. Namely, expulsion cannot be the basis. The expulsion can be the basis. The expulsion can be the basis for disqualification as per G. Vishwanathan. That is the principle laid down. But G. Vishwanathan principle has been put on hold in Amar Singh case. So expulsion cannot be the basis. Then comes the conduct. Have I resigned from the party? I say that issue has never been considered by anybody. The conduct is not one action. There are several actions. Action A is neutralized by action B. So you cannot clutch onto action A and say, no, we will not consider action B. You see my conduct as a whole. Here are the people who listen to the advice of the Honorable the Chief Minister and they have come back to the party. You say nothing doing, we are not concerned with all that. All that is afterthought. We will only consider action A. Namely, you resigned, but you never accepted the resignation. Had you accepted the resignation, there would have been no expulsion. So it's putting cart before the horse either way. So, my lord, I submit. It's a prima facie case for my lord's intervention. Lordship may consider it. Then, my lord, on top of it, Lordship may consider another provision. Assuming for a moment, you say fine, forget about the expulsion. Assuming, I'm sorry. My lord, assuming for a moment.
Volume. It's in volume. Which volume? Arunachal. Volume 8. Arunachal Court.
Hey, listen. It is my chamber. One book is there.
Volume 8.
Actually, my lord,
Volume 8.
Actually, my lord, I have no quarrel with the principle of law. Mr. Mazumdar may refer to Nayak's case, Ravi S. Nayak, etc. I don't dispute the proposition. It is true. An action can also be inferred. But I say, why do you draw a selective inference? You only consider one part of my action. You do not consider another part of my action. The word used is the conduct. If you are looking into the conduct is sum total of so many actions. Not one action only. Section 318.
Which page?
My lord, I have the section 3(1)(a) of the Prohibition of Defection Act 2003, Arunachal Pradesh. Section 3(1) small a. Disqualification on the ground of defection. But their page may not be similar. Or may I help your lordship? Acha.
170.
170.
Yes.
Subject to the provisions of section 4, well, 4 has already been omitted, my lord knows. 5 and 6, a member belonging to any political party shall be disqualified from being such member A, if he has voluntarily given up his membership of such political party. So the expression is, if he has voluntarily given up his membership of such political party. I ask myself, have I really voluntarily given up the membership? Because party is talking about my expulsion. I have not voluntarily given up. And if the party attributes to my conduct of initial resignation, the fact that party started the expulsion proceeding means party never accepted my resignation. And I withdrew the resignation. I ask myself, my lord, why should the party not consider my withdrawal of resignation and my rejoining of the party on the call of the Honorable the Chief Minister? That is my conduct. And if that is my conduct, which has within itself more than one actions of mine, then certainly, my lord, section 3(1)(a) is not attracted. Additionally, I argue the dicta of G. Vishwanath that expulsion from the party ipso facto would lead to disqualification, that principle no longer holds good. Matter is pending reference for consideration of the larger bench. So either way, my lord, I have a case for interim protection. Thirdly, my lord, let us assume for a moment I am not even expelled. Let us assume for a moment my resignation also not accepted. Now, my lord, merger is a legal process. Merger is authorized by law. If I constitute 2/3, I may take a step forward towards the merger. Whether taking of a step forward for merger would ipso facto entail disqualification if the fructification of taking of that step forward has a legal sanction. Because merger has a legal sanction. It gets a protective shield. So if fructification of a particular action of merger has a legally protective shield, then taking an action towards that very particular end also would get the protective shield. Merely because someone is moving towards the merger, you would not circumvent the entire process by trying to expel a person and throwing him out of the party and then say nothing doing, disqualify him, declare his seat vacant. So, my lord, these are the issues for consideration of a lordship on merits. My lord, I just summarize. Number one, whether in the facts and circumstances of the case, whether the appellants are entitled to get the similar protection like of which was given in the Amarsin case. Namely, here expulsion is the basis of disqualification. Since Vishwanathan has been put on hold, whether appellants are entitled to get the similar protection. That is point number one for my lord's consideration. Number two, whether my conduct ipso facto can lead to drawal of an inference that there is a voluntary resignation from the party. Especially when after expulsion I withdraw my resignation also and I rejoin the party. They consider the first part, they don't consider the second part, but in any case, my lord, the party has not considered any of my action. Party has not considered my first resignation either. Party says we expelled you for anti-party activities without spelling out what those anti-party activities are. So therefore, my lord, I submit, looking into my conduct as a whole, maybe, my lord, my conduct as a whole may be the conduct of a very, very highly confused Jila Parishad members. But be that as it may, my lord, here one action gets neutralized by another action. Sum total of all these actions constitute one conduct. The conduct, my lord, gives a very, very, my lord, hazy picture. But if one cannot really firmly conclude that these were the people who wanted to resign from the party and they had voluntarily resigned from the party. So, my lord, I am entitled to the interim protection on that count. That's my humble submission for my lord's consideration.
Well, I wanted to restrain myself from making my submission, but I'll have to make the submission. My learned friend made the same submission before the omni single judge, that in Amar Singh's case, the judgment passed by this Supreme Court in Vishwanathan has been kept on hold. And ultimately, he had to be pointed out by the honorable single judge that this submission is not correct. It is only in respect of two petitioners of that case. My learned friend is again making the submission. He has made not only the submission, he has already also submitted that the Amar Singh law. Amar Singh has not decided any law. Vishwanathan is the law.
Amar Singh law, it never said.
Amar Singh, yes, you have made a submission that
I
Amar
said
Singh
Vishwanathan
principle.
law.
Amar Singh
Vishwanathan
principle.
law has been put
I
on
have
hold.
taken special note, my lordship may go back to the video here. He has made a submission that he is trying to impress upon this court that the Vishwanathan and Ravi S. Nayak have been kept on hold
Not Ravi
by
S. Nayak.
Amar. Yes, Vishwanathan means Vishwanathan, yes. Vishwanathan is the judgment which is coming in the way, and my learned friend is trying to impress upon this court that Vishwanathan has been kept on hold. My lord, lordship, before I go to the Vishwanathan and Amar Singh, my lord, lordship, may kindly have a look at page 34. What is the finding? Because he made a similar submission before the single judge, and I had pointed out, or single judge has pointed out that this is not a correct submission. Don't make it. It is in respect of two petitioners of that case only. But he is making a submission that the Vishwanathan has been kept on hold by the subsequent judgment in Amar Singh. That is not a correct submission, my lord. This submission should not have been made. I am taking serious, my lord, exception to this submission.
The fact
Because
that I
this is
put
the
forward
way if you are
the-
trying to
sorry,
impress upon
the-
a court.
the fact
No,
that
you
I-
have completed your submission. Let
No,
me
no.
make my submission now.
You-
This submission ought not to have been made by a man of his stature, my lord.
was not.
This is trying to, I'm now, I was initially restraining, now I am opening up, this is amounting to misleading some court.
Sorry. These are harsh words, please.
I do not use these harsh words, my lord, today I have to use. Because he is asking for an interim, no. I am only about your submissions. I am making this submission because this is a case where I'll show, my lord, passing an interim order will amount to giving the final relief itself. And the Honorable Supreme Court has regularly deprecated this practice of passing interim order in a case where it will amount to passing the final relief itself. Now, when he has been asked to argue on the interim, he has argued on merit. Arguing on merit is one thing, asking for interim price another thing, for the simple reason that even if you, so I'll show the judgment, my lord. Honorable Supreme Court has said, even if you make out a prima facie case, you will have to show other two things, including the question of public interest. Now, here is a case, my lord. They are not showing anything that if the interim order is not granted, they will suffer any inconvenience. They are only on merit.
Sorry, let me correct for telling
No,
you, my friend.
in between you cannot argue.
Statement is
They have to
there.
complete.
We are elected representative. Our seat has been declared vacant.
My
There
lord,
is none to represent.
my
them.
lord, when an election petition is filed and the election of a return candidate is set aside, is it the ground that the seat will be vacant? So kindly stay and kindly set aside the order. This is the submission is being made. Then what is the use of this election petition on RP Act, my lord? If you say that after election has been set aside on the ground of corrupt practice or any other ground, then since the seat will remain vacant, kindly stay the order, kindly set aside the order. This is the submission. In a sense. Now, Lordship may kindly see page 34, para 23, my lord. This submission in respect of Amar Singh's judgment, how it has been dealt with by the Honorable Single Judgment. Lordship may kindly have a look at para 24, page 34, my lord. In the case of Amar Singh, my lord, may I read, my lord? In the case of Amar Singh Supra, their lordships in the Supreme Court of India had merely stated that the case of G. Vishwanathan Supra would not apply on the two petitioners therein. However, the observations made in para 8 thereof cannot be construed as if the two-judge coordinate bench of Supreme Court of India in Amar Singh Supra had held that the judgment of the other two-judge coordinate bench of Supreme Court of India rendered in the case of G. Vishwanathan was not a good law. My learned friend is saying that it has been doubted.
Yes. Doubted, yes.
And then it has been kept on hold. Where is it?
Yes,
Where is
in
it?
the case of the two
Now,
petitioners.
Lordship, you kindly see this Amar Singh.
Unless you doubt it, you can't refer it to another bench.
In Amar Singh's case, para 9, Supreme Court says, pending the reference, the decision in G. Vishwanath case shall not be applied to the two petitions alone. It's not amount to keep on hold. In the facts of that case, something has been made out. In your case, you have to show that you have been able to make out a case.
That's why
I'll show.
I have read the case.
So, my lord, Amar Singh case is not going to help my learned friends, clients. And the second submission is, my lord, this resignation, my lord, repeated submissions have been made that the merger has not taken place. Resignations, your subsequent conduct of the party shows that you have not accepted resignation. Question is not about acceptance of resignation. Question is not about merger actually taking place or fructified, as my learned friend wants to put it. It is the question, what is your conduct? You have, by filing application, very well clarified, even till the end of filing reply to the show cause notice for disqualification, that had the new district been created, had the new ZPM, Jila Parishad, been constituted in terms of section 85 of the Act by way of a notification, they would have got saved because they are already 2/3. But the question is, new Jila Parishad has not been constituted. That is why they are, till the time of filing their reply to the show cause notice, they are asserting that yeah, we are 2/3 member, meaning thereby that we want to come out of the party, we have resigned from the party. Question is, my lord, what is your conduct? You have expressed clearly that I have come out of the party by putting my resignation and from the primary membership of the party. Secondly, you have filed application for merger. My learned friend is trying to say that there was an intention to merge. No, your application, you have decided to merge. These are the factors which have been taken into consideration by the honorable single judge while dismissing the petition. You made it very clear that you have come out of the party by putting up your resignation. You have filed another application for merger. You have tried to take the protection of the defection law, saying that I'm 2/3, so you cannot disqualify me. Meaning thereby, moment the new district is created, they will come out. That means they do not have the intention to remain in the party. This is what the Honorable Supreme Court in G. Viswanathan, Ravi S. Nayak, and the earlier case of my lord Narendra said that if by your conduct it is clear that you have given up your voluntarily given up your membership, you have to be disqualified. Now I'll show my lord what is G. Viswanathan. Lordship, may kindly have a look, like paragraph 11 of this Ravi S. Nayak, 1994, supplemented 2 is I've given a book list. '94 2 SSC, page 641. There are similar provisions in the 10th schedule. That is why, while interpreting the similar provisions in the 10th schedule, the Honorable Supreme Court in paragraph 11, Lordship, may kindly have a look at paragraph 11 at page 649. My lord, line about 5th from bottom. Paragraph 11, my lord. If your Lordship has got, my lord, the words, a person may voluntarily, Lordship has got, my lord, a person may voluntarily give up his membership of a political party, even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, an inference can be drawn from the conduct of a member that he has voluntarily given up his membership of the political party to which he belongs. Now, you are saying that I have filed application, withdrawing my application for resignation, etc. This grievance you have even against the party. That's a different thing. That at a different level you can fight that. Going again back to the party, kindly accept. But this, the Deputy Commissioner is considering your conduct. Second, my lordship, may kindly see the other judgment. This is my lord Ravi S. Ravi S. Nayak. I have shown. Then G. Viswanathan, 1996. Volume 2 SCC. Para 11. Para 11 then, at page 361. Now, line about 7th from bottom. The further question, right hand side, the further question is, have your lordship got, man? The further question is, when does a person voluntarily give up his membership of such political party as provided in so and so? The act of voluntarily giving up the membership of the political party may be either express or implied. When a person who has been thrown out or expelled from the party which set him up as a candidate and got elected joins another new party, it will certainly amount to his voluntarily giving up the membership of the political party which had set him up as a candidate for election as such candidate.
These appellants have not joined
No,
any political
that's
party.
what I'm saying, my lord. What I'm relying on from this paragraph, my lord, it can be either expressed or implied. As a whole, what is your conduct? As I said, my lord, he has resigned from the primary membership. He has filed application for merger with another party. He has clearly indicated that, see, we are 2/3, so kindly disqualify us. So their intentions are absolutely clear that they have no longer any intention of remaining in the
No.
party.
Come to second part,
My lord,
when a person who has been thrown out.
yes. Yes, here facts are different. What I'm saying is, my lord, their conduct as a whole, this is what has been taken up by the deputy commissioner, by the honorable single judge. Their conduct is they wanted to come out. Subsequently, when actions were initiated,
Conduct includes the joining of the other political party. Another
Yes.
political party.
yes, my lord,
There is a case.
joining has,
they have not
that is
joined.
what, my lord, joining has not taken place in fact. But in fact that you have filed the application for merger remains, and till the time of filing their reply to the show cause notice, they have maintained that. See, if the new district has been, my lord, I'll show. I will show. I will show from their reply that in their reply to the show cause notice, they said that we were under the impression that new district has been created. Now new ZPM also will be created. So 6 members will fall in the new district. So out of 6, 4 will be 2/3. So that is why we wanted. They have never said, so we made the mistake or we wanted to go back. This is not the state. I'll show.
For the purpose of interim,
My lord.
I think since they are the elected representative, we just cannot
My
keep
lord,
it back end.
elected question will be,
Panchayat
question-
later.
my lord, question will be whether their disqualification has been valid or not. Prima facie court has to see if their disqualification is valid or not. The disqualification has been done in terms of the act, which says that if you have voluntarily given up your membership, then, and from your conduct, if it is found that you have voluntarily given up, the effect is you will be disqualified.
No, definitely we'll consider that, we'll determine that, but then for
No, my
for
lord.
the purpose
My
of
lord, this disqualification has taken place at the level of deputy commissioner, before the honorable single judge. Now, if your lordship passes an interim order, it will amount to allowing the writ petition. Nothing will remain in the writ appeal, my lord. It will amount to allowing the writ appeal itself. Nothing will be left to be decided. Then I'll show the next judgment. These 2 judgments are very clear, and the earlier judgment is also there, my lord. Then, my lord, I will show the cite 2 judgments to show that passing of an interim order if it amounts to giving the final relief. 2005, 9 SSC, page 733, my lord. (733). State of View versus Ram Sukhi Devi. Para 8 lords may kindly. Para 8, 5th line from bottom, right hand side, my lord. Time and again. Lordship is a god, my lord. Time and again. Right hand side, my lord. Time and again, this court has deprecated the practice of granting interim orders, which practically give the principal relief sought in the petition for no better reason than that of a prima facie case having been made out, without being concerned about the balance of convenience, the public interest, and a host of other considerations. Here is a case where they have been disqualified. They have come back from the party long back, come out of the party long back. Now, in the writ appeal, if they get an interim order, it will amount to nullifying the order passed by the single judge and then the deputy commissioner. So, in view of all these submissions, my submission, lordship, before I conclude, my lord, I'll just show one thing, my lord, from the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003. The provision, section 3 is very clear. Subject to the provisions of section 4, 5, and 6, a member belonging to any political party shall be disqualified for being such member if he has voluntarily given up his membership of such political party. So that has been taken place. The disqualification is absolutely within the four corners of the law.
I'll take only 2 minutes. I'll give very short.
So we have heard you on.
To reply, 2 minutes, my lord, only 2. First of all, my esteemed colleague submitted that I am making the same submission that I have made before under single judge. Precisely, I will make the same submission since I could not impress the single judge. By same submission, I'm trying to please. Hang on, sir.
No, this is, let us be clear. This is with regard to the judgment of Amar Singh.
Okay, I'll
My
come to that.
learned friend tried to mislead the court
No,
by saying that
please, please.
the judgment passed in Viswanathan has been kept on
No,
hold.
Yes,
and
it is
my-
kept on hold.
My learned friend had to be pointed out
No,
that
no.
now this is not the correct position of
I'll
law.
explain that also. Yes, please. So far as that part of the submission is concerned, my learned friend will agree I can make the same submission before division bench. That is why the writ appeal. So my lord, first part is okay. I can make the same submission before division bench. I can impress my lord with the same submission.
Yes, okay.
Second part, Vishwanathan has been kept on hold, I repeat, in respect of those 2 petitioners. And I'm seeking a similar protection. This is what my submission is. Number 3.
You are not submitting that, you are not saying that it has been kept on.
Yes.
You are saying that
In respect.
In respect
in
of
respect
those,
of
because,
those
so I'm seeking
two
a similar.
petitioners
Yes, yes.
and you are praying
Yes,
similar.
yes, similar protection in the interim. In the interim, I'm seeking a similar protection. Thirdly, the third submission is, my lord, my esteemed colleague pointed out that it is only when I submitted a reply to the show cause notice for disqualification proceeding that I took that kind of a plea. No, it is wrong. It is 16th of April. My reply to the disqualification notice is on 26th of April. On 16th of April, I had withdrawn my resignation. And 16th of April itself, I said that I am joining the BJP. So it had happened 10 days earlier. Thirdly, I reiterate that my conduct is the sum total of number of actions. You cannot pick and choose one particular action and you segregate another action. You have to consider conduct as a whole.
That you have,
And yes,
that you have already.
unfortunately, my lord, here, my lord, they have not considered the conduct. What they have done is only expulsion and you
Sir,
go.
that you have already
Yes,
submitted.
that is all, my lord. That is all.
And what about the amounting to granting finite
Yes,
relief?
that is not a correct
If
submission.
we pass,
That is not a correct submission. If my lord could give me interim protection pending disposal of the writ appeal, it would only mean that I would continue to represent my constituents. Because ultimately, my lord, there is a vacancy. I am a Jilla Parishad member. I have a constituency. I have got a people to look after. After all, my lord, I am not a thug or a thief. I was elected by those very people. I had won the election. That is an aspect to be seen. My esteemed colleague talks about the public interest. I ask myself, what could be the better or bigger public interest than to represent the constituents who had elected me?
Public interest upholding the election law.
I am representing those who had voted me to power, who had made me the Jilla Parishad member. Till the disposal of the writ appeal, My lord, my only worry is once the notification is issued and elections are declared,
That's a fresh,
appeal would be infructuous.
that's a fresh cause of
No,
action.
no fresh cause of
No,
action,
no.
appeal would be
No,
infructuous. The lordship will consider.
The counsel for the appellants, Mr. and Mr. D. Majumdar, learned senior counsel assisted by Mr. S.K. Dairy, learned counsel for the respond number 3,
Respondent number two.
Mr.
Respondent number one.
A. Apang. Learned senior counsel assisted by so and so, huh?
So I think.
For respond number 2.
This one.
And Mr. S. Stephen Senior, learned senior government advocate for 1, respond number 1. In that case, you record it in chronological. 1 first, we'll examine and pass the
Malam,
order in the chamber.
deep level.
My lord, obliged for patient hearing. He could make by.
Well, this is a contempt petition, Malo. Complied. Not much.
It's in the process, lordship. Process
Not
is
big
on
deal.
lordship. No, process is on, I'm saying. Lordship, this is the latest status update. Especially on my part, there is no deliberate and willful lordship, delay lordship. Lordship will see at para 1 lordship. Revised proposal was of compensation was sent on 8/5/2024 by the Deputy Commissioner to the Secretary Land Management. And then we wrote to the Secretary Land Management on 13/5/2024 for early the lordship approval of the lordship proposal, revised proposal. On 22/5/2024 only it was approved by the Land Management lordship department lordship. And on 24/5 itself, we have lordship sent the budgetary support sanction to the government lordship, finance department. And then now it is lordship since beyond 1 crore is to be lordship placed before the cabinet subcommittee for sanction lordship. It is with the chief HMO now. Lordship. CMO, yes.
Cabinet Committee on Staff.
Lordship will see in my instruction lordship, parapide lordship. It is with the, file is with the same.
My lord will kindly
You wait for some time.
Yes, yes, because
lord,
You are
this-
getting the new cabinet today.
my lord, yes, my lord, since more than almost 2 years, my lord.
That
I've been
is-
waiting only, my lord.
And you can have some more patience, yeah?
My lord will kindly, my lord. My lord, I understand. Only the issue like, my lord, when they will pay, because this has been going since long time. My lord, kindly turn to my lord last time, order, my lord.
Now, my lord,
Order of this honorable court, my lord.
If you have waited for 2 years, another 2 months, 3 months doesn't.
Correct.
yes, it has come to me on 24/5
Will not go into the legality.
My lord, I understand, my lord. The last order, my lord, kindly, my lord.
Yes,
I
we
agree
we have seen
I
it.
agree that,
Last order, my lord, last chance,
yes.
5 weeks times to settle the matter without failing which appropriate order will be passed, my lord. Now, my lord, even if,
We
Revised
take
proposal when
it
it
as
was-
a settlement.
then, my lord, some sort.
Because that point of time,
My lord.
they were settling. We
There
need
was
to
no
look
comment,
into, we
cabinet.
need, they have
I
approved now. Only it's a matter of sanction from the finance or
My
some
lord.
cabinet.
That's why, my lord, even if my lord inclines to give time, my lord, some short time may be given, considering the, my lord, the situation, my lord, can see, this is the case, my lord. It's something like from they have been evicted illegally from the house till now, they don't have a land to stay. They're staying in the rented house. Not a single penny has been paid as on today. This predicament has to be also taken into consideration. We are not only that government's concern is not only to be taken into consideration. They have been suffering, my lord.
No, suppose if government is taking steps or this they have tried to
My
take,
lord-
these are the actions.
My
they
lord,
have
I am
already
not
taken.
saying they are
So
not,
if-
but how, since they have been doing since when, man?
No,
What's
no,
about the people,
this,
man?
this is the real, I mean, it's a, they have already started the process. That point of time, nothing was coming forward. There was, it was indicated that they are settling between the, I mean, amongst
That's
the.
why, my lord, some short time may be given, my lord. The common people, their interest may kindly be, my lord. They are in the rent house, man.
After the last order lordship, they have activated lordship.
My lord, may kindly see, my lord, today only the Council of Ministers is being formed, the state of April, my lord. But this is not a, my lord, less amount, my lord. It involves 19 crores, my lord.
Yes, almost 20.
It's not that, my lord, we are not.
So, government is taking 5 weeks because 5 weeks may be required also. In other ways, now new cabinet is forming and otherwise also those things may require some more time.
My lord, I
So let it
understand.
be 5 weeks. Let us see what the
But
results
that's
come.
why only, my lord, no more, my lord, time. My lord, I am not against, my lord, no time should be given. I am saying, my lord, not excess time should be given. My concern may also be taken into consideration. That is only my prayer.
Mr. Alphonse applies for the petition and also had
I am
for
contempt number 6.
MSG, Learned Council for the Learned Council Government for the response number 1 to 7. And Mr. T. Kampu, the Learned Standing Council of Land Management for the response number 3 and 5. And Mr. T. Tara, the response contempt for the number 6. It is submitted by MS created the Learned Senior Government Advocate that the government has already initiated for the initiative in that regard and already submitted and the file is already submitted to the government and the amount of proposal of 19 1 crores
19 crore, 90 lakhs.
19 crores 90 lakhs 11,711 is already request some more time for approval of the cabinet subcommittee and accordingly it is submitted by MST18 that some more at least 5 weeks time may be given for the compliance of the order. In this regard, Mr. R. Suna, the Learned Council for the petitioner submitted that the petitioner is suffering since when your land was acquired.
Hello?
So this is, you have filed this contempt on 2020 and your order was passed on? Order was passed?
My lord, the first single bench order was passed in 27/6/2022.
that was confirmed by the order of the appellate court number 6/9/2022.
Since last, the case is pending since last 2-3 years, and the present petitions are not getting even a single penny from the government, and hence we submitted that no further adjournment may be given to the state government state respondents. Next, considering the submission made by the Government Council for both sides, the report, status report submitted by the senior government advocate. Let the matter be accordingly listed after 5 weeks. After 5 weeks, say they require 5 weeks, so let it be after 5 weeks.
This time at least, my lord, because last time 5 weeks given. This time, last time I did not make any objection, my lord. I conceded, my lord. This all time, my lord, this time.
4 weeks, 4 weeks.
My lord, let it be cited, my lord, because my lord, they are going to get their money, my lord. It's the only matter of this the official procedure, my lord. It needs, my lord.
My lord,
If
my
lord.
If I can convince my brother to wait for 5 minutes, is for this reasons, my lord. Now the council of minister has been sworn in today. Portfolios will be allocated. The minister will take 2 to 3 weeks to understand the department. Then the file
They
will be
obviously,
put up
this
before
will,
the
this entire process
subcommittee.
will come.
cabinet subcommittee approval, administrative approval. Then again, it will go to the concurrence for the finance, to the finance department.
Okay, then we are giving
Then
5 weeks.
after
Let
5
us see.
weeks.
5
You can
weeks,
wait 2 years, we have waited, my brother. If you want money, please don't send the officers
Your
to
money,
jail.
not
No.
going anywhere. Give
and
your
it
money.
is,
this is not the
5
issue.
weeks going to, list after 5 weeks. Okay, what to be like him, so. Let us wait for 5 weeks, let us see.
Yes. This is after 5 weeks.
Much supplies.
Only let's hope next time they again don't ask for another time. This has been repeatedly going, my lord. Much over.
Yes, paper book. Yes. Hearing reading.
May I, your lordships?
It's a case.
Yes, it's a jail appeal. Yes.
For a brief note.
State,
State.
additional.
You are waiting for the private respondent.
No, respondent number 2, legal aid counsel. Respondent number 2, victim, yes.
For the victim.
She's for the victim. I'm the amicus curiae.
So otherwise, the brain will be.
Maybe posted for, yeah, final.
Yes.
I think it is yet to be admitted, can be admitted in fixation.
Fixing a date. It's not gonna be a problem. It's not gonna be a problem. Don't waste time.
How many weeks? Yes, after 4 weeks or after 80 days, before the credit payment, it will be after 3 weeks.
2 weeks also will do. 2 weeks also will do. If I could pray for a fixed date, for a fixed date. Yes,
It should be before the legal has other. When the service.
Thursday. June 27th. 27th of?
Mr. Beer, I am appearing on behalf of Union of India, my lord. Respondent number 1, 2, 4, 8, 9, and 10, my lord. My lord, this sucks. This is regarding construction of, my lord, the strategic role for the defense purpose, my lord. And only because of the pendency of this, my lord, the PIL, my lord, the work is not progressed. My lord, and
My lord, respondent number 6 and 9.
no, my lord. Respondent number 9 has filed affidavit, my lord.
6.
And in respect of other respondent, my lord, my submission, my lord, ultimately, my lord, the alignment has to be, my lord, the alignment, my lord, the where the road alignment has to be proposed, has to be finally decided by the deputy commissioner, my lord, district administration, and as well as the state government, my lord. Of course, my lord, the non-filing of the, my lord, the affidavit by the other respondent. However, my lord, only because of the pendency of this, my lord, the PIL, my lord, work is not progressed, man.
My lord, I am not agree to my friend, my lord. He has said, my lord, realignment is done by the district administrator. That is wrong submission, my lord. According as you say, my lord, is their duty for the realignment, my lord. We have nothing to do with the realignment, my lord. Here is the BRO, my lord, for expansion of two line road, my lord. Alignment, realignment, my lord, district administration, nothing to do that, my lord. It's a wrong submission, my lord. No, we have nothing to do with the realignment.
So there is no interim order is there. You may proceed. What's there? There's no interim order, you may proceed. Whatever you want to do.
My lord, yes, my lord, admittedly, my lord, the purpose, my lord, the difficulty is, my lord, either of the way, my lord, we are agreeing, my lord. We are the only executing agency, my lord, we are the, my lord, my lord, this is basically for the purpose of, my lord, for defense. My lord.
But if it is no injury as such, why did you?
So, my lord. However, my lord,
Yes.
Yes, my lord, I am appearing behalf of this. My lord, DK does. My lord, as per the instruction, he was still, my lord, not filing affidavit in opposition. Other parties, except respondent number 5, 6 and 9, my lord. File in this end. Yes, file. Yes, other than, yes, my lord.
It's okay.
Well-
You are not going to file. Are you going to file the affidavit in opposition or you are not
in
going
that
to
case,
file?
my lord, maybe given some more time to file affidavit, my lord. And my lord, respondent number 9 has filed affidavit for stacking of, my lord, respondent number 9 from the, my lord, from the PIL, my lord. He is not a necessary party, my lord. Respondent number 9.
He prayed to
He has
strike out
nothing
his
to do
name.
with, he
He's not a necessary party.
not a necessary party.
You'll have to file IA for that, not
Yes.
affidavit. It is the affidavit in opposition.
So, my lord.
What the petitioner said, he's a necessary party as per you?
When the meeting was conducted, my lord, these officers went to the place and my lord, they had discussions with the officer. Only because of that reason he has been included. So, my lord, I'll come with the affidavit, my lord, IA for instruction.
Now, it is the petitioner, if you want to say that he is not the necessary party, he may file a petition or you may file a petition to striking of the name of number 9.
Item number 8, yeah.
No,
Respondent
respond
number
number 9.
9. 9 is my, I think it's my
necessary.
lord, the necessary party. And when
Okay. So how many weeks you need if you want to file the affidavit in opposition?
3 weeks time.
my lord, my specific then maybe. My lord, some specific then we fix, my lord.
Date may be fixed.
After vacation.
You are Mr.
A Dalbong.
Card Mr. A W, the learned counsel, also card Mr. M. Carter, the learned DAJ for respondent number 1, 2, 3, 4, 8, 9, and 10. And Mr. Arif Sharma, the learned additional advocate general, appearing on behalf of respondent number 5 and 7. Since that respondent number 6 and 9 has already filed their affidavit in opposition. However, Mr. Carter, the learned DAJ has submitted that 3 weeks time may be required to file their affidavit in opposition. List accordingly, after 3 weeks, you find a date. 16th of July, after reopening of 16th of July is opening, na? After vacation, what? 16th of July,
16 July.
immediately after vacation, 16th of July.
Yes, ma'am.
List after 16th of July, enabling the respondents to file their affidavit in opposition if any. 16th of July. Yes.
Deeply obliged.
I appear for the respondent number 4. If your lordships permit me, may I just indicate your lordships a slight development which has happened.
What is the, why this has been listed to orders?
My lord, we
Yes.
are actually praying for disposal of the matter.
This is just a slight development, your lordships. I think I should just inform your lordships. After the passing of after the writ appeal has been filed on 13th of March, the LOA has been now issued. The work order has also been subsequently on 15th of March been issued. In terms of that, the agreement with the government has already been executed by us because we are the beneficiary of the project and we've already started our work. So that is an aspect that your lordship should just remember. This has been happened after the project on 13th of March.
My lord, by an interim order, it has been observed that any action taken by them will be subject to the final outcome of the writ appeal. So
This is
that
all I
way,
wanted to inform your lordship.
there is no difficulty or impediment in hearing the matter. And the matter relates to when a tender was issued for-
Hear the matter today. Yes, sir. That's what I- Hear the matter. So,
page 78 is the.
Anyway, Mr. Mojumdar, if you fix another date, because single list is also there, already 12:30. If you have any convenient date that can be fixed, otherwise, the case was listed in order column, but it was supposed to be disposed of today.
My lord.
Can this be listed after the vacation? Madam?
My lord, only difficulty is, my lord, after the vacation, when it is listed, again, my learned friend appearing for the private respondent will say that we have progressed so much of work. That is the
The work has
difficulty.
already started, but
No, that it will be subject to outcome. There
Yes,
is
subject
an
to
order
outcome.
of this court. It will, even if he says so,
My lord,
Nothing.
that is what I am saying.
it will have no bearing.
Yes, and the order is also there, is subject to final approval.
Whether you complete the execution or not, this will be always subject to outcome of this.
I just wanted to inform your lordship that this is the subsequent development which has happened.
But authority could have, they have waited so long, the interim order was passed long back, my lord. If they have recently done so, the authority have waited so long, they could have waited for another month, 1 month, so that there's some decisions taken here.
LOA was issued far back in the month of March.
Yes,
Yes.
month of March.
Yes. When the appeal was, my lord, the notice was issued earlier, my lord, long back. And then this interim order was also passed long back. Here is a case, my lord, where the government notification, the CPWD manual, all indicate that how, my lord, the invitation for tender should be published. There was no publication. The GFR they say is applicable. GFR itself says that you have to publish it in such a way that it is published in the Central Public Procurement Portal. Advertisement in the newspaper is a mandatory requirement. Now, advertisement in the newspaper was not done deliberately so that all cannot participate, and the petitioner could not participate. And now you have said that we have settled and finalized the tender. This is the main issue, my lord. Learned single judges dismiss the petition, my lord, without going into the real issues involved, like whether there is a requirement, mandatory requirement to publish in the newspaper or not. That is the issue, my lord. We definitely require some time, my lord.
Heard Mr. T. Majumdar, the learned senior advocate, assisted by, assisted by, as bespoke, the body appellate. And also heard Mr. And written class. Mr. Rotting is appeals for respondent number
I appear
Your
for
for
1, 2, 3, and 6.
1, 2, 3, and 6. Mr. R. Rotting, the learned additional advocate general appearing on behalf of respondent number 1,
Oh, 1, 2, 3, and 5
1, 2, 3, and 5.
in the appeal.
Yes, 1, 2, 3, and 5. And also heard Mr. Your Mr.
RB Fukan for respondent number 4.
I will put on for the respondent number 4. It is submitted by your submission. We are recording your submission.
Great.
Submitted that Mr. Fukan is submitted that the work order has already been executed. Already work order is already issued, and the work is in process in progress now. As per the recent development of the they submitted that the recent development, the work order has already issued and they have started their work, executing the work. The work order issued 3% of NIT, so dated 22/6/2023. Shall be subject to final outcome of the writ appeal. Due to paucity of time, the matter could not be heard today. List accordingly. After vacation, you are saying? After
Yes, 23rd, when is a Tuesday. Tuesday.
23rd of
July.
July.
It's a Tuesday.
It's a Tuesday. No? 23rd of July. Okay. We are listing it on 23rd of July.
Great.
Lordship may kindly observe that any construction made or any work progress made, it will be at the peril of the party, because the Lordship is passed an order. It will be subject to the outcome of the final
Yes.
order. Initially, nothing was done. Now they have recently passed some order, my lord. Right in the beginning, had to pass some order.
Recorded the submission made by the council for the respondent number 4 that work order is already issued and the work is under the executed. So that is this, but subject to, yes, definitely, it will be the subject to outcome of the appeal.
Great.
As I can say, my submission may be recorded, but initially there's an interim order that any order passed by them, any action taken by them should be subject to the final outcome. That may kindly be observed by me, because
Yes, sir.
otherwise,
Yes, it will be the final outcome of the appeal.
that may kindly be observed. My submission may be recorded that there is only the interim order. In spite of that, they have taken this action now.
It's subject to outcome, so that's anyway available. She's already passed an order.
Already there is order
Already
now.
there is order in
Yeah,
place.
order is
Apart from
there.
Your submission, apart from that, if they executed the work or whatever, so definitely it will be the outcome of the appeal.
Yes.
Outcome is
So
subject to the outcome.
That may kindly be lost.
Yes, I will.
It's already there. Why unnecessary?
Madam, when today their submissions on behalf of the Prime Minister is recorded, my lord,
Submission is already
it will
recorded,
send a
yes.
message to the state government as if they have got now the liberty to go ahead.
Intimate your lordship that this has been
Lordship
done.
may make some observations so that when initially, right after the first order was passed, if some action had been taken, the matter would have been different. We would have taken some other steps, my lord. Now, after so long, my lord, they have issued the order.
It is.
They have not even, I
Submission
mean,
of
this is.
it is further submitted by Mr. Mujum, the learned senior advocate, that the interim order was passed in way back in 2023, but now they're submitting, now the S1 number 4 has submitted that work order has issued and they have started their work. So though it was the order passed by this court that it will be the subject to the outcome of the appeal. No, Milai didn't supply. Okay, I will record your submission.
Lordship may kindly observe, it will be taken up for final disposal because today also it has come up for orders.
I don't know.
That gives it in the-
Yes, yes.
Yes.
And the registry is hereby directed to list the matter accordingly. You want to in admission column?
Admission for
Admission column, and endeavor shall be made to dispose of the matter on the date of listing.
Monday. It's better.
Your instruction was sought.
So one I is there.
I.
Yeah.
She told me that operation was done, small operation was done.
In IA, what is the term of sentence, in fact? Under
20,
which section it is?
section 376, 3,
76,
3, 3. For 20 years, imprisoned, like
for 20 years.
20 years.
Have you filed your objection, written objection, any? Lordship, we have received this, Lordship. Medical report. Yes, medical report. This is the medical report.
Lordship, as per this report, Lordship, this is I seek from the ADC Lordship and loss acquisition Lordship. On 8 Lordship, 8/4, they have sent this victim Lordship, sorry, the accused Lordship for the treatment. And their Lordship, the patient has undergone cystotomy Lordship, one endoscopy lithotripsy, which means Lordship removal of kidney stone by small incision cut and crushing of stone by wave therapy into small pieces. That comes out through urinary system. And after that, Lordship, this is the Lordship prescription Lordship. The accused is now undergoing Lordship medicinal Lordship. Undergoing medicine Lordship in the Lordship.
Obviously, the question was that he was supposed to get his surgery done, but the
Lordship, actually
as per the
surgery.
report, as per the doctor's advice, it is seen that most probably this surgery is urgent is not required.
Lordship, as surgery Lordship, as per
That
the
is why the conservative treatment or procedure is not
Lordship, it is
required.
already done Lordship. Patient has gone through Lordship.
Patient has gone through.
Gone to the Lordship, this cystotomy Lordship. This is prescription Lordship. This endoscopy Lordship, procedural Lordship.
From where you are saying that he has already gone under operation, but is there any?
Lordship, it is as per this Lordship, status lordship.
Ah.
He had gone lordship. Now they have come lordship.
No, advised.
No, that's why lordship is medicinal lordship, board of doctors lordship. Their advice is still awaited lordship because this is the lordship, the person who is the in charge of this jail authority lordship, he is in leave. I have received this instruction from his from the WhatsApp.
Whatever
Yes, lordship.
The status report you have received.
Lordship.
From here, it is seen that it was advised for the surgery.
No, lordship. It is already done, lordship.
It doesn't show, it doesn't indicate. It says advice, it was advised for surgery,
Surgery.
but then doctor has refused to carry out the surgery, but decided to apply its conservative procedure.
Lordship. This is the lordship.
This is what can we keep on. From where you have collected this from where?
Lordship, from the lordship, I have got to.
Give in a report, in a form of report or in form of the status report.
Lordship,
Otherwise, it can complete. For whom it is written. for
lordship
whom-
may go to the lordship, lordship. This, I have produced the lordship, the instruction lordship from the ADC, where it is reflected on 8/4/24 lordship. The said convict Priyo Dhawan was sent again to AMCH Dibrugarh for surgery as advised. However, the doctor of AMCH Dibrugarh rather applied conservative procedure. It already applied lordship. That means the patient had undergone symptomology lordship. And after that lordship,
You want to say that the cystolectomy or endoscopic lithotroscopy was done.
done the lordship. That's why lordship, here lordship, doctor advised
Yes,
that
there
rather
is a
applies
procedure by small
lordship.
incision
This is
and
small
then
lordship, yes,
crushing
small lordship. It's a
of this stone.
procedural lordship to lordship,
Yeah, for whom?
that's why lordship, the doctor has lordship, the doctor of MFC rather applies conservative procedure to treat the convict and refuse to carry out surgery. The surgery is not needed, lordship.
How you, from where you have taken it?
Lordship, this is from the lordship, the in charge of the your jail superintendent, jail authority lordship.
You should have collected in a proper
Lordship,
manner.
I have,
Otherwise,
lordship, he is in,
this one is-
lordship, I am sorry to submit that he is on leave, lordship, then he's, that his prayer is that for within few days,
Because
lordship,
now
he'll,
this petition is pending for
lordship.
his disposal, but two question is that one, she is most probably seeking the bail in bail or the by suspending the sentence. And apart from that, he taking another ground that it is medical ground. So that's why we need the report.
Lordship,
Now from this report, it's quite confusing. In
Lord-
one hand, it is saying that he refused to go for the surgery and the conservative treatment is provided.
lordship,
Whether conservative treatment means this,
lordship.
that is not.
No,
that's
lordship,
not-
he's, as per the lordship, the prescription lordship, the doctor has lordship advised that the patient already gone lordship, this treatment lordship. And moreover, lordship, this is the prescription lordship, this is after this procedure lordship, he is in medicine lordship.
Then what do you want
Only
to
the
say?
part is lordship left is that the this board of these doctors lordship, they are certified lordship, health certified lordship, that is necessary lordship. And moreover, as per I telephonically, I have confirmed that now he's doing well lordship in the prison lordship, not he is under medicine lordship. Medicinal treatment lordship, that's it, and surgery is not required lordship,
What is not required?
not lordship.
What required?
Surgery lordship as,
Surgery.
no, not required, this is procedure is already been done lordship.
Yes, what do you want to
Yes,
say?
in this case, Your Honor, until and unless there is a report from the doctors, because whether its stone is still exists in the kidney or not, that is the
No,
matter
as per-
question.
That is to be, but as per this report. She had
cannot say
already
this-
undergone systolectomy.
Stone, that is the
endoscopy.
small incisions that's made in the body, small
No, it's a
incisors and
simple
that would.
Whole leg there and
Yes,
by
whole leg.
petition,
Yes.
it crushes the stone. if the stone, the measures suppose a small thing, then it can be, by that treatment, it can be
It can be removed.
treated.
Yes.
I mean,
Whether after
but-
this treatment, whether that stone was removed or not, that has to be certain.
stone may be, most probably, shock therapy was given to small pieces come out through urinary.
Yes,
Yes, so that has to break down the stones there so that it
Otherwise,
can
if
come
it
out.
is
from-
critical condition, then that lordship status have come lordship. Before there's lordship, as per this status lordship, they had already gone that procedure and he is in medicine lordship, under the medicine lordship. And moreover lordship, only the
Apart
doctors.
from that, what do you want to say in regards to his bail prayer?
No,
One
no,
is a
bail
critical
may
ground.
not be granted lordship because lordship.
Have you filed any objection to the written objection within the 20 years punishment? That's why I'm asking.
No, lordship, I have not been lordship, directed lordship. Today lordship, I have directed to produce the status report of the health of the person lordship, this convict person.
And what, and all the different he is providing with all this information. And if she wants to file a review, if we prepare the Heard Mr. D.K. Devi, the learned counsel for the applicant. And also heard Ms. L. Hage, the learned additional public prosecutor for the state respondent. And you are MS? Huh?
J. Doji.
J. Dozy for the- You are for the just two, no?
Yes, number.
Your amicus or legal aid? Legal aid counsel, MS so and so, correspond number 2. MS L. Hage, the learned additional PP, has submitted the status report received from the Deputy Commissioner of District, wherefrom it is seen that the patient was taken to Dibrugarh Medical Hospital with an advice for surgery, but the doctor applied for conservative procedure for treatment and refused to go out for the surgery. In the meantime, it is submitted. She further submitted that patient has already undergone. It what to likhiri Sister Lovey so and so so and so. And at present, he has been advised with some medicine. In this context, Mr. Devi submitted that from the report, it is not clear as to whether he has already been the stone is already removed through that conservative treatment, and hence he submitted that the proper medical report will be required. Required in regards to the treatment of the convict. Considering the submission made by the learning counsel for both sides, later detailed medical report along with the nature of treatment provided to the convict be called for from the jail authority, from the jail authority post right. The state respondent will take necessary steps in this regard. Further, the state respondent is hereby he is at state respondent is also at liberty to file their written objection if any on or before the next date of listing. List accordingly. How many weeks you need? One last with us after 1 week you take the report. Because the patient, I don't know what is the condition of the patient now. He is improving or treatment the treatment which were then provided to him, whether he is responding or not. This kind of report will be required. So after 1 week we are listing. And by that time, if you want to file any written objection or your oral submission will also do in regards to the bail. So let the matter be listed after 1. We are listing it after 1.
Well, can a date be fixed?
The Thursday, 20. 20.
Thursday.
Oh, just.
All blessed.
Item number 11. Number 11. Yes.
Please, your lordship. Lordship, in this appeal, lordship, we have appeal.
Second of it may continue, right? Because the end of the hearing could take something. 1, 2, 30. Now it is about to be one, in fact. So if we hear the matter, it may continue after two also.
Yes.
Hear matter. In that case, what to do?
Otherwise, your lordship, there is nothing much in this in this present
Can be
appeal.
heard.
Yes, because your lordship, in my humble understanding, I've not only once and 3-4 times I've gone through the record. Even in fact in the before the trial court, the prosecution has fairly submitted that the prosecution has failed to prove this case beyond reasonable doubt.
What's it?
Yes, your lordship. Your lordship may kindly come to the record, your lordship. Because your lordship, there is a gross, your lordship, defective investigation has been carried out by the investigation agency.
Acha.
Nothing has been sent for FSL, although everything was seized, but there is no any FSL. It was not sent for FSL, your lordship. Only on the basis of the statement of the daughter and the husband, your lordship, was convicted.
Convicted under?
Your lord, 302, lordship. 302, yes. Because your lordship
Except
is.
the statement of the husband. There is no
Yeah,
other, any
no
court
other
order.
independent, your lordship, because your lordship is well aware that they come under the definition of related witness. And your lord,
But the principle is that anyway, okay, we can start. We'll continue it after two also. We can start.
Lordship is contended by the PP, Lordship. There is nothing in this case, Lordship, to prosecute me, Lordship. There is only a circumstantial facts that has been stated by two alleged, prosecution witness, Lordship. She is the daughter and then the husband, Lordship. Solely on the basis of these two prosecution witness statement, I have been convicted, Lordship. Lordship may kindly.
But what circumstances say? I suppose if it is, I mean, the case is established under, even under the circumstantial evidence, that may be one of the ground for conviction.
Yes.
I don't know what is the circumstances.
Hello.
They're not gone through. But is there any?
There is no link at all, Lordship. The circumstances that they are trying to prosecute.
Hmm.
Lordship may kindly come to the FIR, Lordship. May kindly highlight the facts of the case, Lordship.
FIR.
Page 3, Lordship.
Yes. It's an unknown female body. Okay.
Lordship, initially unknown body was found, Lordship.
Hmm.
May I read the FIR, Lordship. It is to inform you that on so-and-so, a telephonic information was received from Sri so-and-so, came so-and-so to the effect that unknown dead body was found at Kupurizo village area in cultivation field of one Sri so-and-so, so-and-so. On receipt of the same, a police team rushed to the spot and found one dead body of the unknown lady floating on the pond near the appropriate cultivation hut. During observation of the cultivation hut, it is ascertained that the body of the deceased was dragged and drawn into the pond. The blood stain found in the local kitchen up to the veranda and the weapon of offense, a big wooden stick with blood stain and containing lady's hair is found thrown into the kitchen. A lady's handbag containing medical prescription of dated so-and-so and one case memo of dated so-and-so of purchasing a mobile phone with mobile no written on it as so-and-so of the mobile word new market a paper slip containing number so-and-so and another number of so-and-so were found which have led the identity of the victim. Since the circumstances picture seemed of crime led to a murder, thus I submitted. This was the FIR filed by the inspector A.K. Tanti, who himself has investigated the case. Initially, it was a unknown body that was found, Lordship. Now, the investigation was carried out, Lordship, and they have filed the charge sheet, Lordship. Lordship will see the prosecution history at page 7, Lordship. It's very short, Lordship. I'll just read out for the prosecution. Its story of the case is that on 23rd, so-and-so, a telephone information of ASI Tanagar that once made had telephonically Same thing, Lordship. I'll read.
Dead body was found and so and so.
Lordship, I'll just read this. The deceased was quite healthy from starting from that, Lordship.
Hmm.
The disease was quite healthy and strongly built, and she could not dragged along by Sri Tadenalo, who has been alleged in that case, Lordship, who is handicapped by one hand. It is not possible for him to drag the strongly built diseased lady. There must be another man. The statement of the daughter, Miss Somi Raimuk, and second husband, Sri Lenya Raimuk, who is the prosecution witness 1 and 2, Lordship, point out that the deceased informed her daughter and husband of possible attack by Tadenalo and Lomanguki 2 days before the death of deceased, and also confessing under 161 of committing crime, and later on confessing before the honorable magistrate that the two accused are lodged in the same cell at judicial lockup Dapurizo, and they are plotting to distract the police investigation. True, there is no witness of incident of the murder. The two accused is found involved in the murder of Srimati Yapak Remuk, and there is evidence he is giving warning of dire consequences to late Yapak Remuk similar time on the way, and also the time coming to her house at airfield Dapurizo. This is the statement that was given by this prosecution witness 1 and 2, Lordship. The post-mortem report of the disease has been received. The case is pending. Therefore, I am submitting the case into charge sheet accused Tadenalo and accused Lomanguki under section 302, 201, 34 IPC. Honorable Court is prayed to summon the witness and may kindly summon after fixing the interview. This is the prosecution's story, Lordship. Now the trial, Lordship will see the post-mortem report at page number 4, Lordship, or 14, Lordship. Now here the reports opined, Lordship. We'll see at it is marked in bold letter, Lordship. In my opinion, the cause of death may be due to head injury. The head injury mark present over skull, left side with multiple fractures. Now the allegation is that the deceased was hit by a lock, Lordship, and due to that, that was the cause of her death, Lordship. Lordship will see the seizure memo at page 11, Lordship. That lock that was used was seized, Lordship. Lordship will see at serial number 5.
Measuring so and so with blood stain and hair.
Lordship, one wood measuring 1 meter, having long blood stains and hair, human suspected weapon of offense, Lordship. This was seized. Now, this very weapon that was alleged to have been used, Lordship, this was never sent for forensic, Lordship. That, Lordship, will find that the position made by the IO at page 33, Lordship. In the cross, Lordship, the IO has clearly stated, Lordship, that very lock that was used to kill the disease was never sent before the FSL.
Cross evidence of PW4.
Lordship.
PW4 cross evidence.
Lordship. PW4, Lordship.
Page number 33.
Lordship, relevant part, Lordship will see at page 33. Lordship.
Yes.
I'm reading the 8th line, Lordship. This is the relevant. I did not send the seized exhibits to the FSL for expert analysis and report thereof, as I did not feel of relevancy of FSL report to substantiate, corroborate other incriminating evidence against the accused person, Lordship. It's clearly admitted that the very weapon that was used was never sent for FSL, Lordship. And last part of that very paragraph of the deposition, Lordship, I'm reading that, Lordship, where the IO of the case has clearly stated that there is no eyewitness, Lordship. And he has submitted the charges only on the basis of the circumstantial evidence, Lordship. Statement given by PW 1 and 2, Lordship. I'm reading, Lordship. there is no direct eyewitness to the commission of the offense in this case, and my charge sheet was filed basing on the circumstantial evidence collected by me during investigation. The main circumstantial evidence in this case is the statement given by the daughter and husband of the deceased at the time of occurrence of the incident. PW1 and PW2, Lordship. Now, Lordship, may I take you to the deposition given by PW1, Lordship? Relevant part is at page 23, Lordship. Page 23, second paragraph, Lordship. I am reading that second paragraph. Out of this statement, this very statement, the IO has relied to file a charge sheet, Lordship. Actually, my deceased mother was a first wife of the accused Thadenalo, Lordship. She was the ex-wife of the alleged accused in this case, Lordship. And had even begotten one child, though it was expired. As for disclosure made to me by my mother, Lordship, this disclosure was made before the incident, Lordship. Above main accused, Sri Thadenalo had deserted her for reason not known to her, and sometime in the month of December 2017, January 2018, Lordship. Above main accused, while residing at the same Pakam colony, the project entered in my deceased mother's rented house and attempted to assault her sexually. On self-defense, she caused injury on the right hand of the said main accused with a local dowel and chased him away. Because of his injury sustained, appropriate main accused kept threatening my deceased mother to take revenge against her by killing her. Similar threatening was also reportedly given by the co-accused, Sri Loma Nguki, who has been acquitted during the trial. Nguki, in support of main accused, while my deceased mother was alive, has told me by her, Lordship. This is the whole allegations coming from PW1, Lordship. Now, the point that has to be noted is, Lordship, the threatening and then the convict who has tried to sexually assault is of December 2017, or he is not rightly pointing out the dates, but he has tried to mention the months, Lordship. December 2017 and January 2018.
The incident had happened?
The incident had happened in 23/7/2019, Lordship. That is after 6-7 months. Lordship.
Okay, we'll hear that. Okay, we'll hear later part at 2.
Lordship.
At 2.
Okay, okay, Anuj.
Government side, state. Anyway, you start. Because we have a single bench also, no, both of us. So try to get.
Lordship, I was on the deposition made by PW1, Lordship.
In page 23.
Page 23, Lordship. Lordship, in the cross, Lordship, regarding that allegation that certain threatening was coming from the alleged accused, Lordship, convict. In the cross, Lordship, last part of the line, Lordship. Indeed, incident took place after 4 days of the last threat. We also did not lodge complaint before any authority for the threats given to my deceased mother prior to the last threat, since we wanted to avoid further untoward incident with the main accused. No such FIR, Lordship. Now, Lordship, PW2, Lordship. Rest of the witnesses, Lordship, apart from these 2 witnesses, Lordship, the doctors and then the IO of the case, Lordship. IO of the case I have read out, Lordship. This is PW2, Lordship, page 29, Lordship. Page 29, Lordship.
Please.
He's the husband of the deceased. Page 29,
29.
29.
Yes.
Same statement, his date of PW1 lordship has been disposed by, I'm reading lordship.
Hmm.
My deceased wife had informed me before she was murdered that after quarreling with main accused Tadenalo is the ex-husband of the deceased lordship.
Yes.
She was warned on more than one occasions of dire consequences by the accused persons. So lordship may kindly note this dire consequences. Nowhere it is maintained that he is going to kill or something like that. Even time of 1 week was given by the co-accused to harm her. Meantime, I had to go to Taliha as a GB to attend the call of Honorable MLA Sri Nyato Rigya, taking advantage of my advantage. Of my absence and old age, main accused with the help of co-accused Sri Lomanguki had murdered my wife after planning and being aware of my wife's work at garden for cultivation and collection of vegetables. Both the accused person had executed in murdering my wife jointly as because co-accused had an appears with the sister of the main accused at that time. This is the whole allegation, lordship. Now rest of the PW's lordship, they are the seizure witness, lordship. Lordship, may I take you to the deposition of PW3, the doctor, lordship, who has conducted the post-mortem. Lordship, we'll see that by the time the body was recovered, lordship, the body was decomposed, almost decomposed. Lordship. I'm reading 9 line, lordship.
Hmm.
I found a body including internal organs fully decomposed. This is the deposition given by the doctor, lordship, who has conducted the postmortem. Upon my further examination of the dead body, by unfolding the foreskin of the skull, I found multiple fractures on the left side of the occipital region of the skull, and to my opinion, it must have been caused by blunt weapon, lordship. Now, it is not disputed that the blunt of weapon was also seized, lordship. Lordship, I have shown the seizure memo, lordship. But here, lordship, admittedly, lordship, London court below also has admitted that there has been certain discrepancies during the course of investigation, lordship. That has been, though all those things ought to have been sent for forensic, lordship. Then there could have been any sort of link, lordship. Now here in this case, lordship, solely basing on this statement given by PW1 and PWT, drawing a circumstantial facts out of it, lordship, the alleged accused has been convicted, lordship. Lordship, the judgment of the London court below is at page 44, lordship. Two issues were framed, lordship, during the page 49, lordship, paragraph 7, lordship. Analysis and appreciation of evidence, it is at page 65, lordship. Paragraph 20, I'm reading, lordship. It's admitted, lordship, by London court below also, lordship. To begin with, it is a fact that there is no direct witness or evidence to the commission of offense of homicide in this case, and the prosecution has been set up basing on the circumstantial evidence. One of the main circumstantial evidence is the relationship between the main accused A1 Tadenalo and the deceased A's husband and wife, and a repeated threat of dire consequences given to the deceased by associate A1 and co-accused A2 prior to the incident. Paragraph 22, Lordship. As per section 32 subclause 1 of Indian Evidence Act 1872, statement written or verbally of relevant facts made by a person who is dead or cannot be found or who has become incapable of giving evidence or attendance cannot be procured with Lordship. Here, Lordship, their sole basis of convicting the convict is under section, they have relied on this particular section, section 32. This is the dying declaration, Lordship. Actually, this is it was a hearsay, Lordship. It's not a dying declaration, Lordship. Lordship is aware, Lordship, how the dying declaration is to be taken, Lordship. Now, on this, solely on the basis of this particular facts, Lordship, the deposition given by PW 1 and 2, Lordship, I've been convicted. Lordship is aware about the laws, Lordship, laid down by Honorable Apex Court, Lordship, regarding circumstantial evidences, Lordship. I have brought to authorities on this, Lordship. Asar Mohammed and others versus State of UP, Lordship. 2019 12 SCC 253, Lordship. I'll just rely on paragraph 8 and 9, Lordship. The legal position laid down in respect of circumstantial evidence, Lordship. Lordship is aware, Lordship, the test that has to be undertaken, Lordship, while appreciating circumstantial evidence, Lordship. Lordship, I may not read out also, Lordship. It's already known, Lordship. And I would like to rely one more judgment of this coordinate bench, Lordship, passed by this coordinate bench, Lordship, 2022 2 GLT 595. Similar situated kind of a facts, Lordship.
Yes.
Basing on circumstantial evidence, Lordship, they were convicted and the matter went before appeal, and all those thing was argued, and ultimately court could acquit the convict, Lordship. Relevant paragraph is, Lordship, 5, 6, 24 and 25, Lordship.
Your Lordship, I would like to assist this court so far as the discrepancies and the material which pointing on the guilt of the accused. Your Lordship, prior to that, Your Lordship, I would directly take your your Lordships to page number 50. The submission made by the additional PP, page number 50 of the Your Lordship judgment rendered by the learned court, trial court, para 8, Your Lordship. Then I will come to the evidence, Your Lordship. Para 8, Your Lordship. May I read, Your Lordship?
Yeah.
The learned additional PP has submitted that the prosecution could not prove the case beyond reasonable doubt during trial and thus left the matter to be decided by the court finally. So, Your Lordship, the prosecution perhaps not made any endeavor to find out the material, because, Your Lordship, I will point out the incriminating material which pointing on the guilt of the accused, and Your Lordship, the investigation, the manner in which the investigation has been carried out. And for that reason, your lordship, the circumstances and the link cannot be completed in this case, your lordship. Your lordship, I will take your lordship directly to the inquest report, your lordship. Firstly, when the dead body was found, your lordship, initially in such circumstances, inquest has to be done in accordance with section 174 of the CRPC, which is absent in this case, your lordship. Your lordship, inquest report is in. Inquest report is in page number, your lordship, in 9 and 10, your lordship. Page number 9 and 10. Here, your lordships are aware that inquest has to be done in presence of magistrate, by the magistrate. But here, from the initiation of the investigation itself, your lordship, the inquest has done by the concerned IO itself, your lordship, in presence of inquest witness, that is the daughter of the deceased person. And your lordship, I will just point out the dates, your lordship, because here the case is, in this kind of cases, circumstantial evidence, the time, date matters, your lordship. So here, your lordship, the inquest was done on 24/7/2019. That may be recorded, your lordship. And your lordship may see in serial number 3, place and time where the dead body found and traced. That is on 23rd. So now, your lordship, first I will establish the time, your lordship. And your lordship, the serial number 5 is the body identified by the PW1 daughter. So now, your lordship, may directly come to the deposition of PW1. This page number 22, your lordship. No doubt, your lordship, the statement given by the daughter, this is the deceased daughter, is sterling in quality. Why, your lordship, even the accused side, defense side, they are unable to shake the statement given by the defense witness one statement. However, whether that will suffice to convict an accused, that is the question here, your lordship. Now I will read that the relevant portion, your lordship, from on oath itself, your lordship. I know both accused person standing in the dock, whose name are Sri Tadanalo and Sri Loma Muki. My deceased mother, late Yapak Raimuk, was a vegetable vendor. She was a vegetable vendor, your lordship, who used to collect vegetable from the garden at Kuporijo in the early morning every day and sell it at Daporijo market. Your lordship, Daporijo market, she usually went there for sell the vegetables. As usual, she has collected vegetable and left for Daporijo market on 21st. This is the day when she went missing. 21/7/2019. However, at the usual arrival time in the evening, my deceased mother did not return to our brother-in-law government quarter at Airport Colony, Daporijo, where we were residing. Even after my inquiry telephonically or otherwise, I could not get any information regarding whereabouts of my late mother. On the next day, on 22nd, the very next day, I had gone to Talia to meet my father, and on my return to Daporijo in the evening hour of same day, I had come across the social media that one lady dead body was found at Kuporijo area. Then I tried to ring to my late mother once again, but could not get her. So I went to PS Daporijo for police help, but they could not help in the view of the jurisdictional issue of the case. Accordingly, I went to PS Dumporijo along with my brother Tare Raimuk, one of the prosecution witness, and his friend Jido Raimuk. But again, police at Dumporijo PS was not ready to help us in finding the late mother body, though they already found her body in the pond-like area in Kuporijo on the ground that it was already late night and dark. Though we attempted to find out the deceased mother body in the intervening night of 22nd, 23rd July, your lordship, basically the body was found on 23rd. Your lordship has seen the inquest report. It was found on 23rd, but inquest was made on 24th. We could not find her body in the morning of 23rd. That means, your lordship, body was in the morning of 23rd. We and Daporijo police could find out the body of my late mother at Peace Pond, like near our vegetable garden at Kuporijo. Upon the closer examination, we could see the injury on the forehead and backside of the deceased mother. Now, from here, your lordship, the inference can be drawn that the body was found on 23rd and inquest was made on very next day. The death is confirmed regarding the dead body, recovery of the dead body. And the other thing is, your lordship, she has duly proved the postmortem examination report, your lordship, other exhibit. Now, your lordship, the second para. Actually, my deceased mother was a first wife of the accused Tadanalo, so and so, and had been gotten one so and so, as per the disclosure made to me by my deceased mother. Now, your lordship, this basing on this statement, your lordship, learned trial court has taken aid of section 32. That is basically for the dying declaration, your lordship. Above main accused so and so has deserted her for the reason not known to her, and sometime in the month of 2017, January 2018. Above main accused, while residing at the same Pakam colony, Daporijo, had entered to my deceased mother rented house and attempted to assaulted her. On self-defense, she caused injury on her right hand of the said main accused with the local dao and chased him away. Because of the injury sustained, aforesaid main accused kept threatening my mother to take revenge against her by killing her. This is the statement, your lordship. The incriminating statement against the accused, your lordship. So now this part, already my brother has, your lordship, pointed out repeatedly. Now, your lordship may kindly come to cross-examination, your lordship. So as to find out the time gap, your lordship, when she was last threatened, your lordship. In page number 24. We did not lodge any complaint. But now it is a fact that to that effect, no FIR, nothing is there to substantiate that. It's just a statement, your lordship. Kaba authority or police after threat was given to my mother, this is the accused person, because we did not expect that the accused or any of his family member or relative would come forward to discuss, negotiate the matter properly. And so we did not expect any person to render legal assistance to the accused in the case of lodging complaint to police. Now this part. Indeed, incident took place after 4 days of the last threat. This is the part, your lordship, because this can be taken into evidence because it is come up during the cross-examination, your lordship. 4 days prior to the, so if 4 days prior would be, your lordship, 16/7/2019. Because on 21, she went missing. And 4 days prior to the last threat would be 16/7/2019. Only basing on this statement, your lordship, the time can be, inference can be drawn. Now we have to see whether there is a corroborative evidence so far as the death of the accused, deceased person is concerned. Now, your lordship, there is a gross error committed by the medical officer who has conducted the PM, your lordship, postmortem, your lordship. Your postmortem report is in page number 13, your lordship. Your lordship, I will point out both, your lordship, the incriminating part as well as, your lordship, the error whichever has been committed, your lordship. 13 is the, from 13 onward, your lordship may kindly come to page number 14. Your last column, your lordship, assistant surgeon, opinion of sub-assistant surgeon as to cause of death. In my opinion, the cause of death may due to head injury, the injury mark present over skull left side with multiple fracture. Here, your lordship, in the postmortem report, no opinion on finding of the time and date of death of the deceased person has been opined by the doctor. And that can be seen from the deposition made by the, your lordship, the concerned doctor itself, your lordship. Your lordship may kindly, but however, your lordship, on the deposition, he has given the rough date or the timing of the death, your lordship. It's in page number 30, your lordship. Lordship may kindly come to page number 31, cross-examination. Yes. Since dead body was already in decomposed position, death of the deceased must have been caused 2-3 days prior to the death of my PME, post-mortem examination. Date of post-mortem examination was indeed, Your Lordship, it was on 24th. And as per his statement is 2-3 days prior to the date of PME, that will be date 21/7/2019 or 22/7/2019, as per the statement, Your Lordship. And it corroborates with the statement given by the daughter, Your Lordship, 21st. She went missing on 21st, and now it's corroborated to some extent. Yes, it was true that I did not mention the exact date of the deceased in my PME report. Normally, human body take 42 hours to get decomposed. Partially, it is possible to sustain multiple fracture with simple hit by single hand. It is also possible to get such multiple fracture injury with the fall hit on heavy object like tree or stone or any other similar heavy object. I could not collect biological sample for FSL. Here also, Your Lordship, FSL was not sent, the biological sample of the deceased person. An expert Europe as of only external but no internal organ of the deceased were already decomposed, which did not enable me to collect such sample. And now, Your Lordship, the third last line of the paragraph. The injury, Your Lordship, on the same day, on 24 itself, the co-accused and co-accused medical examination was also conducted. To that extent, he has given the statement here. The injury sustained by one of the accused person, this is the convicted person, Tadanalo, was pressed at the time of examination. The age of injury sustained by Tadanalo was 24 hours. Again here, Your Lordship, in the medical report, injury report, age of the injury was not opined. But here he says it's 24 hours old. But so far as the deceased, your time of death and time of death.
Now, see, question is that it was already decomposed from that aspect. The doctor has said that it may be within 2-3 days because
Yes, Your
generally
Lordship.
decomposition started after
Yes, Your
48
Lordship.
hours. But here in this case, when the accused, both two accused persons were most probably arrested or apprehended by police or whatever, in that case, there may be a assault in them. For that reason only, he submitted that the injuries must have been within 24 hours.
Yeah, here, Your Lordship, one more issue here is, Your Lordship. By the time when the body was recovered, on 23rd body was recovered, on 24th inquest was made. On that day, as per the statement of PW1, the present convict person was also present when the body was recovered. And as per the statement, as per the 313 statement of the convicted person, he sustained injury on his left eyebrow as per his statement. But so far as the statement of the PW1 is concerned, and the doctor observation is concerned, he has sustained injury in the right eyebrow, Your Lord. And see, as per his statement 313, he sustained injury by the time while crossing the barricade, he has sustained injury. That was his. Now, otherwise, Your Lordship, this is only the statement of the PW1 and the corroborating statement so far as Your Lordship, the statement regarding the threatening was given by the father. That is the PW number 2. The other two prosecution witness has not stated about their enmity anything. And the PW1 has also stated that there was an enmity between the murderer and the convicted person. That enmity. So now, Your Lordship, the question here is, if there exists enmity, there comes the question of, Your Lordship, false implications. Now, no doubt there was no any enmity between the PW1 and the convicted person, but enmity between the deceased person and the convicted person, Your Lordship. And the statement, if we take the statement of the PW1 cross-examination, she was lastly threatened 4 days prior to the incident. So now the issue here is whether it can be get the status of dying declaration or not. That is the issue. Because as Your Lordship is aware,
it should be immediate.
Yes, exactly. There is a huge proximity. It should be a close one. And Your Lordship, The same should be reliable, trustworthy, and on the basing on the last dying declaration, Your Lordship, no doubt the accused can be convicted solely on the basis of. However, if it's related to the related witnesses, Your Lordship, the court has to properly, carefully scrutinize the statement, evidence given by the related witness before coming to any conclusion, Your Lordship. Otherwise, Your Lordship, even the evidence of the investigation officer, it clearly reveals that no doubt everything, Your Lordship, the log, the hair, the blood, everything was there in the place of occurrence, but he has not sent it for FSL. If he has sent it for FSL, then the case would have been different, in different footing. Now, it is difficult to link the chain, Your Lordship. Only on the basis of PW1 and PW3, the inference can be drawn that, yes, there was an enmity between both of them. Basing on that, presumption has been drawn that this was the person who has committed the offense. But no any other material is there to connect the link. And Your Lordship, this is the well-settled law that in circumstantial evidence, all the facts and circumstances forming chain of circumstances have to prove beyond reasonable doubt, consistent with the hypothesis of the guilt of the accused and inconsistent with his innocency. So now, Your Lordship, here is absent here in this case, clearly submitting. Otherwise, Your Lordship, no other material is there so far. And in fact, Your Lordship, the judgment whichever is with me is in fact in his favor only, Your Lordship. The most of the judgment, so far as Your Lordship, regarding the dying declaration, even the dying declaration, it should be, the proximity should be close and it should be trustworthy and reliable, Your Lordship. But here is a time gap is so much that any person may come in between, because in circumstantial evidence, Your Lordship, we have to prove, basing on the evidence, that it was only the accused.
Where's
And that's to be.
where's the question of dying declaration here?
Your Lordship, the learned court below, trial court, he has convicted on the basis of section 32.
31. The relevancy, it has been brought to that 4 days prior or 5 days prior to the occurrence. So he reported before the doctor that he has taken that function. Otherwise, not like.
Only that, otherwise there is no any, only basing on the section 32, the conviction was made. Your Lordship. That much only.
Okay, reserve for it. Okay, judgment is reserved, I passed it. The person is still in the jail or
He's still in jail.
still in jail? Since when he is in jail?
Lordship.
2 years, Your Lordship.
Since 2 years. Sir.
Since? 2
2
years.
Yes.
I mean, from the date of conviction.
2009, on 19, it was, the offense was committed, alleged to have been committed. He was convicted, date of sentence is
2022. 2022. Lordship, since 2022, Lordship, he's in the jail. Since 2022.
2024 only.
22.
22.
Uh-huh.
6-4.
Okay, I'll pass. Reserve, order is reserved. Okay.
Deeply obliged, Your Lordship.
Obliged.
If I suppose that's. Can it be listed before the court number 2? Or you have to deal by me? In that case, I won't go into take. Tomorrow, I'm also the urgency. So let it be on Monday then.
Lordship, the similar matter has been taken up, but
Whatever, let it be on Monday because I don't have time with tomorrow. I have to rush to Guwahati. Some other problem is there.
then Lordship, court number 2 then.
No, I don't know the procedure. If I allow your mention, can it be listed before the court number 2? That is
Lordship,
the
today
issue.
if time
Otherwise,
passes,
I can.
It will hardly take 5 minutes, Lordship. The similar.
No, I'm not going to take any because I have some other problem. That's why. I'm gonna take it. On Monday, it can be listed on Monday otherwise.
Yes, Lordship. Lordship, I beg to mention item number 24 of today's list, 24. In fact, Lordship, Mr. Tiwari was here.
24.
Yes, 24. It's a supplementary hearing. In fact, it will take time, this matter, and Mr. Tiwari has already left. So can it be taken on 22nd of July?
Us. So again, that order we have come up before this court. So some urgency is there because on in the year 2025, I think the term will be also over. So there's some date.
Yes, 22nd of July, because on that
Today,
day,
what is your problem today?
Mr. Tiwari is conducting the case. He has
Oh,
already
he has
left. He left. Because this case will take at least 2 hours or 3 hours. And he is
fixed date on 22nd of July.
22nd of July. Monday.
Monday. I have.
2nd of July is a Monday.
Yes.
Monday.
I saw
But
you
if you are,
waiting since.
I
morning.
know, there is another case. If it is not inconvenient to your lordship, let it be on the top of the list because this is the election matter.
On 22nd only.
On 22nd only.
Request made by Software, request made by the Running Council for both sides. Let the matter be listed on 22nd of July. However, the registry may be directed to list the matter on the top of the list.
I am deeply.
But top of the list.
In the hearing,
procedure
In the hearing list.
in here, top of the hearing list.
In the hearing.
Top line.
My lord, I beg to mention item number 22, my lord, supplementary hearing, my lord. My lord, actually this case earlier it was conducted with other counsel and in the meantime he expired, my lord. And I have entrusted this case, my lord. So going through this paper, I've seen like some document is missing, my lord. So I need to verify it, my lord. So
So you are duly engaged for the petitioner.
my lord, I'm petitioner, my lord. So I've taken consent from the other party also. Respond. Can this be matter be released after 2 weeks, my lord? In the meantime, I will verify the document, my lord. Because earlier counsel.
The landed counsel for the petition, and with the consent of the other side, he submitted that he need 2 weeks time to prepare to prepare the case as he received the brief. When he received the brief recently.
My lord, exactly, my lord, it's been.
Okay, anyway, we have received a brief recently from the petitioner side. Now see, this is a matter of 2015.
That is why, madam. 2 weeks, madam, within 2 weeks, we'll try to dispose of, madam. There's a difficult from the other party also, from respondent side.
It's after 2 weeks, as an
Deeply
executive by the registry. And both the parties are hereby directed to proceed with the hearing on the next day without.
Deeply.
May, my lord. My lord, I beg to mention item number 18 with consent from the petitioner, other party. This matter may be listed after 3 weeks.
Why?
My lord, the respondent was supposed to file affidavit, but some clarification was sought. Now, instruction has been received.
No,
By next-
respondent had already filed their affidavit.
No.
Not yet filed.
Not yet filed. Have
So
received
you
the
are
instruction.
representing whom?
I'm representing respondent number 3.
3.
Yes.
I am the petitioner here, my lord. I am the petitioner.
We have received the instruction and in the meantime, we'll file the affidavit.
Heard Mr. Udeka, the landed counsel for the petition, and also heard Mr. You are Mr.
T. Omo.
T. Omo, the counsel for the respondent number 3, and submitted that he needs some more time to file their affidavit in opposition. Instruction you have already received or not yet received?
Yes, received.
As they have already received the instructions from the authority concerned. Respondent authority. 2 weeks time you need.
Well, it may be 3 weeks.
3 weeks, list after 3 weeks.
Most of them.
List after 3 weeks, enabling the petitioner side to file their, respondent side to file their affidavit. Okay.
My lord, I beg to mention item number 12. Item
One,
number
two.
12. 12, that
Yes.
is with the petitioner, I have received only one affidavit of opposition from the government side, but yet I am yet to go through.
So in
So-
item number 12, you are for the
12.
petitioner?
12, yes,
Ah,
12. So
now
we are filing a rejoinder here. So,
you have already filed,
no,
yet to file.
yes, I will file. 2 weeks' time is necessary.
Madam.
Heard Mr. U. Decker, the learned counsel for the petition, and also heard Mr. T. Tagun, the learned counsel for the respondent. It is submitted by Mr. Decker that the petitioner will file the rejoinder affidavit against the affidavit in opposition filed by the respondent. Considering the submission made by Mr. Decker, let the matter be listed. How many weeks you need?
2 weeks' time.
List the matter accordingly after 2 weeks. As an entity.
Deeply.
My pleasure, Lordship. Lordship, I beg to mention item number 1 to 11. On behalf of D. Kamruk, Standing Council of Land Management. Some more time may be given to file counter affidavit, Your Lordship.
On behalf of D. Tamko.
D. Kamruk.
Why he was?
May I, Your
present?
Lordship?
He was present in the morning, huh?
Yes, he is in court too, Your Lordship. In court too, Your Lordship.
Yes, what you want to say?
I'm for the petitioner here in this case, Your Lordship.
So he is seeking adjournment,
Yes, Your Lordship. They were supposed to file counter affidavit, Your Lordship.
counter affidavit.
Yes, Your Lordship. Your
You
Lordship,
have not prepared it.
No.
Till now you have not filed.
Not yet filed.
Your Lordship, last chance may be given, Your Lordship.
3 weeks
Since-
may be given. 3 weeks may be given, Your.
Your Lordship, on many occasions, they have sought time for filing counter affidavit, Your Lordship. It's been 2 years, Your Lordship.
Yes, 2020.
Yes, Your Lordship.
Heard Mr. So the learned counsel for the all are moved there for the petitioner, and also heard Mr. So appearing on behalf of Mr. D. Kamruk, the learned standing counsel of the land management. And it is submitted that you need 2 weeks.
3 weeks, Your Lordship.
3 weeks' time will be required to file their affidavit in opposition. Full stop. Next, para. In this context, Mr. So the learned counsel for the petitioner submitted that they may be provided with a last chance for filing their affidavit in opposition, as the matter is pending since 2022. Full stop. Next, para. Hearing this submission made by the learned counsel for both sides. List the matters after 2 weeks, no?
3 weeks, Your Lordship.
After 3 weeks. And the respondent side is hereby asked, directed to file their affidavit in opposition on or before the next date of listing without fail. That may be considered as a last chance for filing their affidavit in opposition. Okay.
Deeply obliged. May I, Your Lordship? Lordship, I beg to mention item number 14. I'm the petitioner of this case. So, dependent of the counsel is coming from the Guwahati. So,
You are on item number
item number 14 here.
14.
Yes,
Yes, counsel is.
coming from Guwahati. So, today she couldn't make.
So in this case, it is listed for admission column. The other side is still not appearing. In list 14, item number 14. You are on item number 14, no?
Yes.
You are appearing for Mr. A. Bhattacharya.
Yes.
So on the last occasion, most probably it was a case that was fixed considering the submission of both the parties. both body councils. Now, on the last occasion, the standing council, MS Bora submitted that there may be some pass certificate of the higher secondary honor
Yes.
that has to be produced. Have you produced anything in that regard? Documents? You don't have any
Lordship, I
idea?
don't. Fix that may be given.
Heard Mr.
24.
Swenso appearing on behalf of Mr. A. Bhattacharjee, the learned counsel for the petition. As per the order dated 7/6/2024, and the petitioner was directed to produce all the relevant documents, including the birth certificate of higher secondary examination. But it is seen that the petitioner has not filed any such certificate. And in this context, Mr. So-and-so, the counsel appearing on behalf of Mr. A. Bhattacharjee, the engaged counsel for the petitioner, that he has to take instructions from the concerned advocate. List the matter accordingly after 2 weeks. Okay.
Oh, Lordship, I beg to mention item number 16. Mentioning on behalf of N. Pada, Standing Council for the Tourism, on behalf of respondent. It may be kindly listed after
Why it is listed in order column?
Standing Council Tourism.
No, why it is listed in order column?
I'm not aware of that.
So you are representing respondent which
My lord, I am for
number
the
15.
petitioner, my lord.
Huh?
I am for the petitioner side, my lord.
Oh, sorry, petitioner side.
I'm mentioning on behalf of respondent, Tourism Department.
Now, as per the office note, it is seen that the AD card received in respect of respondent number 15. So now the service is already completed on all the respondents or not yet?
12 to 13 and 14, I believe it's not written.
13 and 14.
And they are
And you are
newly
for?
newly implemented private respondent.
Newly implemented private respondent.
13 to 15. 15 have been written from.
15 is
private.
already returned. 13, no, still awaiting. Nikki.
In that case, my lord, I may be allowed to take fresh steps on 13 and 14.
But 13 and 14 is still awaited. But as per the note of the registry on 25/8/2019, and the unserved notice was returned, with a postal remark that addressee left. But again on 415, item for respond number 15, and again on AD card received in respect of respond number 15 after due service. So that is 15 is already served.
Yes.
13 and 14 are still awaited. So if you want to take fresh steps, you can take fresh steps.
Yes, I will take, my lord. I may be allowed to take fresh steps, my lord.
Okay. Hard Mr. You are the Tam
M. Doji, my lord.
M. Lole, the learned counsel for the petition, and also heard Mr. So-and-so appearing on behalf of
And Pada.
and Pada for the respond number. How many respondents you have?
Respondent number 1 to 4. 5. Tourism Department.
Respond number 1 to 5, the tourism department. From the office note, it reveals that the AD card on the respond number 15 is returned after due service. However, the service is still awaited for newly implemented respond number 13 and 14. In this context, Mr. Lawyer, the learned counsel for the petition submitted that he may be allowed to take fresh steps on the respond number 13 and 14. Prayer allowed. Issue press notice on the respond number 13 and 14 within 1 week. Release the matter accordingly after 3 weeks.
Yes.
Deeply obliged.
But now this is a case of 2015 in fact.
Yes, ma'am.
So
My lord, I beg to mention item number 17, ma'am.
yes, item number 17.
Yes, ma'am. Matter may be taken after a week, ma'am.
I request you are for the petitioner.
I am for the petitioner, my lord.
The request made by the learned counsel for the petitioner with the consent of the others, with the consent of the other side. The learned counsel for the petitioner make a request to adjourn the matter today. Prayer allowed. List the matter only week
After a week, my lord.
after a week. List accordingly after a week. As on the date to be fixed by the registry.
My lord, item number 23 also. I am for the petitioner here. Respondent here.
Lordship, item number 23, I'm for the petitioner, your lordship.
You are for the petition.
Lordship, this matter may be listed after a week because there's an urgency, your lordship.
Okay.
I'm challenging the order of the district and sessions allow. The interim granted by the CGM allow has been set aside. So I have, by filing this criminal revision petition, I have put to challenge.
Heard Ms. N. Anju, the learned counsel for the petition, and also heard M. Doji, the learned counsel for the respondent. Why you need adjournment today?
My lord, the conduction counsel Deepangin is late in court too, my lord.
However, considering the submission made by the learned counsel, Mr. So-and-so appearing on behalf of the engaged counsel, Mr. Deepangin, the matter is adjourned. List after 1 week?
Lodge.
List after 1.
Obliged.
Obliged.
First, I will take your lordship to the last order, page 417. 417, last page, the last page. 417. 417. This is the WPC 401 2021 V file. Tunku Pulu. And kindly see the order 6/11/2023. Learned counsel for the petitioner submit. He has received instruction from his client to withdraw the present writ petition with a liberty to the petitioner to file a fresh writ petition if so advised. The state council has not objected to the above prayer. The instant writ petition stand dismissed on renewal with liberty as paid for. So this writ petition was filed by the petitioner, who is a present petitioner in this case, and it was withdrawn on the ground that there was some talk. The government has given a letter to us, say that we want to, this is against an award which was passed in our favor. The NHPC wants the particular to put a power plant there. So they want certain land. And this land, we are the landowners. And ultimately, they said that this particular, they will put a project there and they will shift those persons to another place for rehabilitation and resettlement. But they have not done it. So ultimately, the government calculated an estimate was made and ultimately found that 42 crores has to be paid. Now that 42 crores was not paid. So we have approached this honorable court by the earlier writ petition 401 that your lordship has looked into it. Now the NHPC, the requiring authority, they appeared before the court. They filed an affidavit. They also filed a cross writ petition that is 242. 242 of 2020, 21, 20, day 5. Now, my lord, once we file a writ petition 401, that said we enforce the award, they came up before this court and they filed a writ petition challenging the award. They said that this award cannot be passed. 42 crores is too high. So I estimate they have lot of reasons were cited, which was under the scrutiny of the court, which is pending. There was some the
242 is still pending.
still pending. Now, in that 242, some assurance was given that why don't you withdraw this writ petition and we will compromise and we'll pay the amount. And ultimately, it was not done. In the meantime, NSP also has not withdrawn the writ petition. In that writ petition, we filed an IA, which has been annexed for enforcement as well as for an interim order to be passed, because we are entitled to get some interim protection from the court under the act, about 14 crores. Because we fall under the scheduled tribe, there is a particular section 41 of the act where we are entitled under the new act, we are entitled to get 14 crores of the total amount. Now, when this was pending and when the matter came up, when it came up, so we have as per the advice of our client, we decided to file this writ petition because liberty was taken. Ultimately, for enforcement of the award, you have to file a writ petition to get a mandamus from the court. You cannot get it by an IA. So hence we have filed this writ petition. What your lordship we want, a notice may be issued, and my lord, my learned friend who is appearing for the state government, they may immediately give a response to it. Because that case has been fixed on 22nd of July. 22nd of July. 242 of 2020. That has been fixed on 22nd of July. So there are two things. One is that let the state response to our affidavit within the shortest possible time. We have to rejoin now the main NHPC. NHPC, there is no standing counsel. My learned friend, one of my friend is sitting here, but he said, I cannot accept. Otherwise, it would have been faster. So what I pray that register ID with dusty service we will take up. We'll take a dusty also. There is no standing counsel. And in this case also,
Standing counsel of NHP is not there, I think.
no,
Today is not available.
today, standing counsel, they said that we cannot accept
अच्छा,
because there is no standing counsel.
No standing counsel.
They standing
But
counsel.
standing counsel, I think there is a standing counsel of NHPC. No. Is there any? Standing counsel of for NHPC?
My learned friend, Mr. Tiwari appears in NHPC case. I told him, why don't you accept this?
No, Lordship, we are being engaged on case-to-case basis. We are not a standing counsel.
You are not standing counsel.
Yes.
No, that's what I am asking. Is we don't have any standing counsel for NHPC? Yes, no. Oh, then it will be. So then, Mr. Kapin is appearing for two.
Number 3.
2?
3.
You are for 3.
3.
And 2 is by you.
Yes, my lord.
And what about 4 and 5?
4 and 5 is
4 and
we have
5
to,
also most
my
probably.
lord,
by the,
so
yes.
far as 4 and 5,
1, 4 and 5.
we'll take register ID plus dusty.
My lord, in that pending writ petition, my lord, which has been filed by the NHPC, my lord, we have filed our affidavit there in that case, my lord. And we are taking the stand that, my lord, NHP, the petitioner here now in this writ petition, they are entitled. So we cannot take different stand in both the writ petitions. So our stand
They
will
are
be the same,
entitled.
my lord.
You're saying they are entitled.
Yes, we are supporting the case of the
State is
petitioner.
supporting us.
Yes, yes.
But the problem is NHPC. Now they have taken a different stand. No, how the estimate was prepared. You cannot have.
Why they have filed the other WPC, NHPC?
They have challenged the award.
Oh, award.
42 crores were passed in our favor, they have challenged the award.
Oh, acha, it's telling you that award.
Yes, that
In
award.
fact, my lord, government is not happy with this NSPC that they are dragging the case before this honorable court. They will seek the help of the government. Government will assess the compensation, and when everything is final, they will come with this.
I'll tell you.
Different writ petition.
Yes.
There
There are.
we are
Yes.
putting all these man and material for all this acquisition purpose.
Why they are doing this?
So
And today, all my people are suffering. Neither they have been rehabilitated or resettled. All they are suffering. Not today a single penny has been paid. All these other project, they have acquired. Lot of the land has been acquired by them. In other cases, some award has been passed, like us. What they have done, they have gone and settled outside the court. Suppose some award is 1,600 crores. They said, let us settle outside it. We'll pay you 640 crores. So then when the award is passed by the government, they go and settle outside it. That's the whole issue. That is why this 42 crores has not been paid. Our whole stand is that we are not going to settle. We are not going to settle the instruction from our client. Not a single penny. If they say 20 lakhs you take, we are not getting 20 lakhs. Whatever the outcome the court pass, we'll accept that. We'll not challenge. We'll not accept them. And my lord, we have also prayed for an interim prayer here. So notice may also go here. Notice may also go because they are suffering. All these people are suffering. Not even a single 42 crores. The state government is supporting us, and a cabinet decision has been taken by the state. Now,
So,
today,
but the question is, if they challenge the 42 crores award, suppose.
yes,
That matter is, that matter is fixed on 22nd of July.
22nd of July. Only what I am worried, if today I can say that let this matter be tagged along with this, if Dusty has to be complete, so what I am praying, let the Dusty be complete and fixed on 24th of this. We'll take as fast as possible. So if this matter is listed on 24 and Dusty will file an affidavit, and if they have to come, somebody will represent. Then what? Then on 22nd we can fix the matter. In the meantime, party can file affidavit.
Mr. D. Dust, a senior counsel. Assisted by Mr. Fukon is assisting you. You are assisting?
Yes.
Assisted by Mr. Fukon, the petitioner, and also heard Mr. D. Kamdu, the learned standing counsel of land management, appearing on behalf of the respondent number 2. Respondent number 2, and also heard Mr. Esther P., the learned senior government advocate, appearing for the respondent number 3. This is a petition you write from here. This sound is very high. Here from here you can write. This is an application section so this can be here from here. Issue notice, issue notice. However, no formal notice is required to issue on respondent number 1 and 3. Issue notice to the respondent the request on the prayer made by the learned counsel for the petitioner. Issue the notice as on the usual process as well as through Dusty note. And the to raise it will go and affidavit will run. Considering this submission made by Mr. Dance, the learned senior advocate, let the matter be listed on 24/6.
Yes.
We are listing on 24.
Yes, right.
24/6. Otherwise, we have submitted that the you made you're supporting the case of the
yes, my lord, in that writ petition filed by NSPC.
okay, then
we have
it
already
is on 24/6.
Yes, ma'am.
It may be subsequent. It may be on 22nd.
My lord.
So, my lord, will the interim order or for interim also notice may go on.
Yes, yes.
Interim, we have played for interim. Page 47.
Page 47.
Sorry, it's 48. 47 in the.
So you want to, I mean, for the interim prayer also.
Interim prayer.
By the
please
notice.
Yes, notice on the interim.
In respect of the interim prayer made by the petitioner, the notice may also be issued to the respondent. Into a prayer of releasing 14 crores, huh?
14 crores. Because
Releasing of
yes,
14 crores.
some amount, this is disturbing. Actually, there's some new documents we have annexed here. So I think my learned friend has to go through it and he has, because he's supporting us. Certain documents we have annexed. It's up to him to file it.
What is the
He
say
files
of the
it, it
government?
is good.
State,
Take instruction from that.
otherwise also if this is the case, suppose, and the management is
Otherwise,
supporting.
award was passed by me, Deputy Commissioner. I have to support it, but even then I will take instruction from that.
All are supporting except NHPC is, no, they are objecting to it. They just want to, honestly, they want to bargain it. Say no 42 crores, how we can calculate? In so many cases I can show. That's why it has become bulky and we have annexed certain documents to bring notice to the court. The same project. Project is one, different land was acquired. Now they have compromised and in that they are saying that 25% net value. They are saying that is there. Now they are saying rehabilitation resettlement policy 2008. How can we pay? But of course that was paid. Today you cannot take a different stand.
Obviously.
Because while the matter was taken up, listed that day, and this we filed an IA. Then I thought that IA, how the court on an IA can enforce an award. You have to file a separate writ petition. That's why the writ petition is being filed.
On 24/6, it will be fixed and subsequently it may be tagged with it.
Yes, correct. I am deeply obliged, madam.
You are staying back today or going?
No, we are going.
Somehow I have to stay today. Then
No,
tomorrow I'm
tomorrow.
going.
That's why I didn't trouble the election matter. Because if election matter continues, your lordship will go in tomorrow again. That's why we fixed on Monday. At least Monday, it will be easier. Deeply obliged.
It is 24/6.
The name of IDAS also can be shown here. R. Fukan and IDAS.
R. Fukan and IDAS.
IDAS.
Okay. Assisted by R. Fukan and IDAS. Oh, yes, it's will. Item 13. I think you are here.
13 euros.
You have already filed your affidavit in opposition, I think.
Yes, Your Lordship.
But they are supposed to file the affidavit in reply today.
Yes, Your
Well, as per the office note. But the last occasion they praised time for filing their reasoned or affidavit. Anyway, the petitions remain absent on call. Heard Mr. I. The learned government advocate. Wairam, Ronek advocate. You are for two.
All the respondents. All the respondents.
For all the respondents. It is submitted that the affidavit in opposition has already been filed by the state respondent. However, from the office note, it is seen that the affidavit in reply is not yet filed by the petitioner side. List the matter accordingly after 2 weeks.
Obliged, Your Lordship.
Yes.
My lord, here, my lord, this is the much, my lord, the awaited, the affidavit has come and by the state respondent, my lord. And the state affidavit filed by the
Affidavit, you have filed the affidavit.
No, my lord, I have raised the question of maintainability and today is fixed for hearing on the question of maintainability, my lord.
Oh,
So, my lord, I may be allowed to start by submissions.
so you're raising the point of maintainability. Oh, yes, that's occasion also. Yes, Mr. Kato, he is raising the point of, basically the point of maintainability.
My lord, may I begin? My lord, this writ petition is directed against the order of recalling and cancellation of the LPC. That is annexure 1, page 22 to 24, my lord. My lord, basically the grounds of challenge to this order, if we'll go through the paragraph 11 and 12, my lord, may I just take your lordship to page 11 of the writ petition, paragraph 11. Lordship, paragraph 11. May I read? That the petitioner respectfully submits that the petitioner, being a bona fide owner of said plot of land, have applied for issuance of LPC by following all formalities in a prescribed format. Now, these are the basic grounds. As such, there was no any such lapses or irregularities on the part of the petitioner, but non-issuance of notice upon the respondent number 5 cannot be a ground for cancellation of the already issued LPC in as much as if there is no provisions for sending notice upon respondent number 5 is not mistake or irregularities on the part of the petitioner, as things which are not required to be done under the government prescribed rules and the format cannot be done by the petitioner. Therefore, there is no irregularities and in violation of principle of natural justice. Therefore, the impugned order that such and such is liable to be set aside. Then paragraph number 12 also. But I'll concentrate on paragraph 11 first. It basically is that there is no such guidelines for issuance of the LPC. And non-issuance of notice to me cannot be a ground for cancellation. And there is no there is no provisions for sending notice, and there is no violation of principles of natural justice. My lord, in the state of Arunachal Pradesh, we have guidelines for issuance of the LPC. My lord, may I read, my lord?
Yes.
Issue opposition certificate their procedure thereof. The government has been considering to evolve a proper and simple procedure for issue of opposition certificate to the owners of private land in various places of Arunachal Pradesh. Such certificate is considered most essential by an individual for obtaining financial assistance from various institutions such as nationalized banks, AP State Cooperative Bank, Tea Board, Coffee Board, Rubber Board, Industrial Development Bank of India, etc. In view of the above, the government has decided to adopt the following procedure for issue of possession certificate in favor of the land as and when desired. A, the landowners who desires to obtain possession certificate in support of his land, he/they shall submit an application in the form prescribed at annexure A, along with the following materials, documents to the administrative authority of the area where the land is located. 1. Certificate from the Forest Department mentioning the land in question does not fall under reserve forest area. 2. Certificate from the village council, village headman, village president or social committee that the land is actually owned by him and he is not a joint property, as well as land is free from all encumbrances. 3. Sketch map of the land in booklet, duly countersigned by the vice president, such and such, such and such. Then part B. On receipt of the above application, the administrative authority of the locality shall arrange to inspect and measure the land in question with survey team, for which he shall issue a notice as per form prescribed at annexure B with a copy to the following persons of the locality, such and such, Gambura, Gram Panchayat members, Council Committee, applicant, persons holding land at neighbors. C. On completion of the above inspection, the administrative authority shall
arranged to issue a notice of no objection from the public of the locality as per form prescribed at Annexure C. On completion of above course of actions, if it is established without any doubt that the applicant concerned is sole owner of the land, the administrative authority shall recommend the case to the concerned DC as per form prescribed at Annexure D for issue of possession certificate. The DC on receipt of the recommendation from the administrative authority shall examine the case, and if it is found in order, he shall recommend the case to the government for approval, and after obtaining the approval, they shall arrange issue of possession certificate as per Annexure E. A void certificate circulation. Number, this was slightly amended. The next page. In partial modification of the office memorandum number such and such as all ADCs holding independent charges in the state are empowered to issue land possession certificate up to 5 hectares for any purpose, including such and such. That otherwise, from the earlier LPC, it is only the government who will issue, even if it is 1 biga. Now, all the procedures has to be followed, but if it is within 5 hectares, the concerned district magistrate, the DC or the ADC headquarters, they can issue the certificate. Now, the Lordship may kindly come to paragraph 3 and 4, and page 27. Page 27, Annexure 3. This is for the first LPC, and Annexure 4 is for the second LPC.
Page number?
Annexure, page 27, Annexure 3.
Yes.
Well, here, how this application was routed through, nothing is given. No date when this was applied, and the Form A is at page 28, next page, Malan. Lordship, page 28, notice. Malan, on the right side on top, number, date, these are all blank. When a case is processed, it has to be number. File number is there, procedure number will be there, date when it is applied, when it is processed, will be there. But there is nothing in this. Now this is the documents annexed by them. This is spot verification, supposed to be spot verification, to be taken up on 10/7/2018. Well, here, no memo number, nothing. How this notice was issued, nothing. Then, well, at page 29, it is supposed to be the public notice. Here also, no memo number, no date, nothing. Page number 29, except their own entry, there is nothing. Then, no. Then at page 30, it is the no objection certificate. No objection certificate, it is here also, my lord, no reference, no file number, no date, nothing. Only it is just shown that inspection was done, and only the head Gambura has signed this. This is supposed to be the no objection by all the neighbors, north, east, south, west. This is the only documents for LPC number 1. From LPC number 2, Annexure 4, the next page. But I'll just here also the same thing. nothing in except for page 31. Page 31 onwards, page 31, 32, 33, 34, 35. The same, my lord. No number, no file number, no date, nothing, no memo number, whom it was issued, nothing. So, perusal of these annexure 3 and 4 clearly shows that there is no certificate from the forest department certifying that this does not fall under the forest reserve for forest, and there is no sketch map. These are the basic, although the guidelines are not in the form of an act, but then when guidelines has been framed, it has to be followed. So therefore, the requirement from a certificate from the forest department is not there. Sketch map is not there. There is no certificate from the village council that the land belongs to him. And another is there is no such records to show that the land was surveyed by the survey team, and no notice of no objection to the public was issued. It was all these documents were made under the table, surreptitious manner. And you know, Lordship will find the person who is signing this, all this document from page 27 onwards, the authority, he is the same person who is signing all the documents, including the LPC at page 36. Page 36 and 37. He is a extra assistant commissioner. He is not additional deputy commissioner. There is nothing to show that he was made the in-charge additional deputy commissioner. Therefore, this is totally in violation of the guidelines. Then, my lord, I come to paragraph 12 of the writ petition. Another reason, grounds assigned. Paragraph 12, page 12, my lord. That the petitioner respectfully submits that the LPC already issued in favor of the petitioner by following the procedures and formalities by the office of the predecessor of the respondent number 5 cannot be normally interfered with by the successor. It means to say that when the EAC has already signed, ADC could not have recalled it. Unless there is a violation of such procedures, he's making a proviso, unless there is a violation of such procedures and any such flaws in issuing LPCs, inasmuch as while allegation against this office of the respondent number 4 and their officials cannot be held responsible for by the petitioner. Further, in Balijan, the EAC are being posted as ADC, and by virtue of the said post being ex officio, such power is vested with the office of for issuance of LPC. Therefore, there is no such infirmity in issuing LPC in favor of the petitioner. Petitioner being lawful and rightful owner of the said plot of land. Therefore, the inferior order successors is number in paragraph 11 and 12. They are talking about non-violation of the guidelines. And also, there is no question of principles of violation of natural justice. In this connection, whether there is a violation of principles of natural justice is there or not, may I just take your lordship to the annexure 1, page 22 to 24. I'll come to straight to page 23, my lord. This is the decision of the ADC recalling order. Paragraph 9, my lord. Now, my lord, before I read paragraph 9, I'll read paragraph 7 because this also will become on the next argument, my lord. Paragraph 7, page 23, my lord. Unfortunately, this office is conscious of lack of jurisdiction on claim of ownership or competence to make any finding on the ownership of the land in question or any other claims put forward by that is the petitioner. Now, my lord, since ADC this is only a quasi-judicial proceeding and there has no civil power, so he's making that I am not making any opinion on the ownership. That is for the court to decide. Paragraph 9. These officers peruse the official records of the process of issuance of the LPC and also compared with the annexures attached by the complainant, Srimati Sasensas, Eliza Sensas. It is revealed during the statement that Srimati Sasensas was not aware of the entire process of issuance of LPC and that non-issuance of notice to Sasensas, Eliza Sensas suffers from irregularity and in violation of the principle of natural justice. And it may be noted as such that the LPC application form does not have any provision in format for issue of notice to dispose for inspection and written objection. Also, it is pertinent to mention that both had purchased the land in the year 2012, but Sri Kabak alone got LPC issued to him without any knowledge of Srimati Bigi Sapyong, Eliza Sensas. Sri Kabak had also mentioned this. Therefore, my lord, this is a clear finding that land were purchased by court. And non-issuance of notice to the wife, it may not be specifically directed to the wife, but then general notification should have been issued. And non-issuance of this is violation of principle of natural justice. And the lordship, when a decision has been wrongly arrived at, when certain formalities has not been followed, and it is always permissible to recollect also. But in that case, on that point, I just want to rely on 1994, 1999 for SEC. May just page 401, paragraph 8 and 9, Malad. Subject matter is slightly different, but then in our opinion, Malad, paragraph 8. In our opinion, a tribunal or a court may recall an order earlier made by it if 1. The proceedings culminated into an order of order suffer from the inherent lack of jurisdiction, and such lack of jurisdiction is patent. 2. There exists fraud or collusion in obtaining the judgment. 3. There has been a mistake of the court prejudicing a party, or a judgment was rendered in ignorance of the fact that a necessary party had not been served at all or had died and the estate was not represented. The power to recall a judgment will not be exercised when the grounds for reopening the proceedings or vacating the judgment was available to be pleaded in the original action but was not done, or where a proper remedy is in some other proceedings such as by way of appeal or revision was available but was not availed. The right to seek vacation of the judgment may be lost by waiver, estoppel, or acquiescence. 9. A distinction has to be drawn between lack of jurisdiction and a mere.
In which way?
Malad.
You are supporting 1994 for.
And 1999. 1999.
1999.
Malad, I think I have wrongly written. Sorry.
1999 you know.
Malad, that loss you'll say because I have.
And you'll give them. 1999 ko nikah.
1999 4 SCC.
Yes.
Now, my lord, another point is that I will come later. Another point is, my lord, in this entire writ petitions, there is a claim that the land is his. And also there is a, this is the fact that there is a dispute between the claim of ownership. And this has been reflected in the order sheet also. Now, my lord, when there is a disputed question of facts, but whose ownership it is for the court below to determine. Now, this is respectfully I submit that this is a writ petition. This writ court can it go into the disputed question of facts. So, my lord, on this account itself, this writ petition cannot stand. Now, there is alternative efficacious remedy, my lord. The first is Arunachal Pradesh has enacted Civil Courts Act. Your lordship is aware. That was in 2021. That was amended also. And the courts has been provided. Customary court, judicial, civil court, and all this, my lord, up to the district court. My lord, the territorial pecuniary jurisdiction has been assigned to various courts, and so therefore, if at all is any claim over the land, it should go to the proper court. Secondly, so that efficacious alternative remedy is available. Writ court is not the forum where can raise the question of ownership. Secondly, Your Honor, the Arunachal Pradesh has also enacted Arunachal Pradesh Land Settlement Records Act 2000 in
Page number.
at page 202. That is Arunachal Pradesh Land Settlement and Records Act 2000. 2002 must be the same. Is it
202?
202. Arunachal Pradesh Settlement. Your lordship got it. Now, let us come to.
No. Sorry, sir. You are saying 202.
Page number 202. Can I just
Which volume you are?
volume 7, no?
Volume 7, page 202. It's the owner of the process. No, it's not the 202 is something about the allowances and all. It's 7 only, na?
Of that act. Section 95. Section 95, chapter 11, my lord. Chapter 11, section 95, the provisos also.
Yes.
May I read, madam? 95. No suit or proceeding shall unless otherwise. No suit or proceeding shall unless otherwise expressly provided for in this act or in any other law for the time being in force, lie or be instituted in any civil court with respect to any matter arising under any provisions of this act. provided, well, provisions are more important. Provided that if it is, if it in a dispute between parties, a question of title is involved, a civil suit may be brought for the adjudication of such question. Provided further that the civil court shall have jurisdiction to decide any dispute to which the government is not a party relating to any right or entry which is recorded in the records of rights. Now, my lord, if it is a dispute between my claim as an individual and the government, then the civil court has no jurisdiction. Now, if it is a private dispute, then this act itself provides that it is the civil court who will decide the title of the land. Now, my lord, he has, the petitioner has filed this writ petition claiming claiming right over the land without going into the appropriate forum. Now, he has not filed any appeals against this or any other challenging this order. Now, in the meantime, I have respondent number 5 has approached the customary court claiming over the title. After issuing notice and all others to the petitioner also, and upon his participation, the title was decided in my favor. As of today, the court below has decided in my favor. In the meantime, what the petitioner did is, in this writ petition, he had filed the interlocutory application number 191, challenging the Kava decision. This honorable court did not agree with that, did not interfere, and made an opinion of that, we have the liberty to approach any appropriate forum. Now, against that Kava decision that rendered by the customary court, title suit is pending before the court of Civil Justice Senior Division, being title suit number 5 of 2023, and it is pending, my lord. So, my lord, he had now at least approached the appropriate forum. Its legality and validity will be argued there. It is only for the knowledge of this honorable court that this writ petition does not lie in any case at this stage, because this has become infructuous. Not only on the question of non-maintainability or not following the due procedure as per the guidelines, otherwise also, this writ petition has become infructuous. Oh, my lord, it is not title, it is civil appeal. My lord, I'm sorry. Now, just because the LPC has been recalled, it does not mean that his right to claim over the title has been stopped. That is why I have also approached the appropriate court, and appropriate court has given that
This
judgment.
petition is for what, in fact?
My lord, rightly pointed out by the counsel for the other party. My lord, my basic contentions in this petition is regarding, my lord, the illegal arbitrary cancellations of the 2 FPCs, my lord, issued by the respondent number 4. Therefore, my lord, in one, my lord, may I submit in other way that once the, my lord, this in both the impugn order is set aside, definitely, my lord, the titles and the rights and the titles over the said land will be decided by the civil court, my lord. That part, my lord, we don't have any objection, my lord.
rightly, my lord, if lordship interferes the impugn order, my lord, the legality and the validity and the of this, my lord, the impugn order, my lord, rise titles over the said lanes is decided by the civil judge. My lord, that is one, my lord, correctly, my lord, the one proposal, my lord. Then I'm agree with that first part. What I'm contending in this repetition is, my lord, if lordship peruse the impugn order passed by the land court, my lord, the additional deputy commissioner order is, my lord, is perverse, my lord, it is arbitrary, my lord, it is illegal, my lord. That is the whole contention, my lord. By virtue of this cancellation order, my lord, the other party approached to the civil court, my lord, customary court, and customary court, considering the facts on the facts that already LPC issued in favor of me has already been cancelled by the additional deputy commissioner. Therefore, my lord, the ways has been clear, the path has been clear, and accordingly, my lord, decided by the village authority. Had it been, my lord, I've specifically pointed out also in my read petitions, my lord, had it been the case then, if my two LPCs are not cancelled, my lord, definitely, my lord, the civil court will decide it. But in my case, first cancel the LPCs basing on the, my lord, the flimsy ground. And, my lord, subsequently they approached to the, my lord, the customary court. See, the LPC issued in favor of me has already been cancelled by the additional deputy commissioner. So therefore, you kindly decide the titles and the rights over the said land. And accordingly, that has been decided, my lord, in violation of the provision, my lord. Therefore, my lord, we admittedly filed before the, my lord, appeal before the civil judge senior division, and that proceeding is still going on, my lord. Well, that has been raised in that civil appeal. So that, my lord, the court below will decide. My lord, I'm not on that merit of the case, man. But, my lord, this is the factual position. Now, my lord, I'll go by the order passed by the additional deputy commissioner. What he has done is, my lord, for a moment, my lord, may I take your lordships to page number 23 of my read petition, my lord. Page number 23, my lord. I'll start by reading, my lord, page, paragraph 9. Hello, may I read, my lord? This office has perused the official records of the process of the issuance of Srimati so and also compared issuance of the LPC and also compares with the annexes attached by the complainant Srimati so. It is revealed during the statement that Srimati so was not aware of the entire process of the, my lord, aware of the entire process of issuance of LPC and non-issuance of notice to Srimati so, my lord, private respondent number 5, Srimati so suffers from irregularity, my lord, and in violation of the principle of natural justice. It may be noted that the LPC applications form does not, my lord, she has also recognized that there is no provision, my lord, does not have any provisions in the format for notice to spouse for inspection and written objection. And it is also, it is pertinent to mention that both had purchased the land in the year 2006, but Sri Kabakbar, the petitioner, my lord, alone got LPC issued for himself without any acknowledgements to Srimati so and so. Sri Bhatt has also mentioned in the second the hearing about the non-interference from the HAR on the said land, which also indicates that Srimati so had rights over the land, madam. Well, just for a moment, I'll pause here, madam. It is the fact, as Lordship has already seen, the prescribed format of prescribed by the state government as well as the deputy commissioner. There is no provisions for the service, issue notice to the spouse, whosoever may be, spouse, spouse means, it is given that this is not correctly exactly
the,
She is the spouse of,
my lord, the factual position was, she was the petitioner first wife. my lord.
oh,
After my lord separations for almost 15 years, my lord. 15 years after separation, my lord. He applied for the, my lord, the issuance of the LPC from the concerned authority, my lord, by following all procedures. And there was no any objection, my lord. There was, my lord, the no, LPCs are not being issued in a day, in a night, my lord. It has to be, my lord, notice has to be issued to the, my lord, district administration as well as other public places for a month, my lord. If there is no any, my lord, the claims and objection received from the anybody, my lord, from any quarter, my lord, the LPCs are being issued, my lord. Now, my lord, I am asking myself, my lord, if I applied for the issuance of the, my lord, the, my lord, LPC, my lord, if anything has been wrongly done by the office who is empowered to issue LPC, if such violation is, my lord, is my responsibility. My lord, my submission is, it is not at all, my lord. It is the deputy commissioner, it is the additional deputy commissioner who is powered to issue LPC. My lord, if procedures are not being followed, my lord, I cannot be held responsible. But my lord, what I'm contending is, I am the owner, my lord. I'm in for peaceful possessions of the same plot of land for last.
that, but while issuing the LPC, suppose the lady was in possession.
Yes, madam. My position.
Then she may be a spouse or whatever. Why didn't you issue notice to her?
Madam, there is no provision, as Lordship has already seen.
No, she is not a spouse only. She is also occupying the land, na?
No, madam. She was not in occupied of the land, madam.
She was not in occupation.
No, madam. My lord, for
it
that
is-
moment, my lord, may I take your lordships to the pictures, my lord, the annexures which I have given. My lord, photograph clearly shows that I am in still possession of the, my lord, said land, my lord. Now, that is disputed. My lord, she has never been there after separation, my lord. And photograph which I have given.
It's 25 and 26.
Annexure 2, my lord. Page
Yes.
25. My lord, the photograph in the lady is my mother, my lord. My mother is residing there, my lord. I'm cultivating, my lord. And I'm doing horticulture, my lord, activities, my lord. And my lord, brother's son was also buried in, my lord, lordship has seen in the memory, my lord. Page number 25, last portion. And page number 26, my lord. My lord, if such is the position, my lord, had it been the case there, my lord, I'm asking myself, and I'm asking also my senior counsel, have you ever annexed the documents showing that you were in positions of the, my lord, the said land? Nothing, my lord.
So basically, your LPC was cancelled by this order only because that she was not aware about the.
Correct, my lord.
Ah.
That was the, my lord. Therefore, my lord, exactly, my lord, cancellation was done only considering only facts that you have not issued any notice to the spouse. My lord, my time and again submission before your lordship is, there is no, my lord, provisions for issuance of notice to the spouse, man. And prescribed duly, my lord, the prescribed format duly, my lord, the
But it's from the submission by Mr. Patil. It is in that he is raising the issue of maintainability. As because the land is decided, the title or whatever is decided by the landed court below in favor of him, and that agreed to that you have already filed an appeal.
My
It
lord,
is
yes.
still pending.
My lord.
So he submitted it in such a situation where the declaration has already been made in her favor. So this is not a proper forum or proper approach. That is his position.
Correct, my lord. Therefore, my lord, I have shown your lordships to the impugn order. The, my lord, impugn order may be interfere, my lord, interfere with Malad, once the interim order is set aside, Malad, obviously, Malad, the legality and the validity will be, Malad, the rights and title over the said land will be decided by the learned court below. But Malad, my contention is
That will be not the case.
Malad,
If this request is
Malad,
allowed, and then the recalling order is quashed and set aside, that means this owner without is declaring the ownership of the land.
Malad, without Malad, approaching to the civil court, he approached to the again the additional deputy commissioner who issued the Malad, the LPC for cancellation. Malad.
Yes.
The LPC, Malad, once it is issued, Malad, is it my fault, Malad? I'm asking myself. I am a mere citizen, my lord. I can apply before the concerned authority for issuance of any documents, my lord. If the procedure is not being followed by the any incumbents, my lord, whosoever may be, my lord, or the any staff, am I responsible for the such the mistakes or the the procedural the violation?
Oh.
And my lord, just to clarify that, my lord, the prescribed everything has been done, my lord, by the state government. Therefore, my lord, last occasion also I insisting for the filing of the affidavit, my lord, by the state respondent. Now, state respondent has filed affidavit, my lord. There is no much, my lord, the clarity about. May I take your lordships to the my lord, the annexures of my writ petition, my lord, annexure 3, page number 27 again. My lord.
2021.
My lord, page number 27 is the my lord, the duly prescribed format prescribed by the state respondent government. My lord, may kindly see to the additional deputy commissioner, my lord, Papumpari district, Palijan, through purpose pursuit. My lord, everything is given. Land description, my lord. May I take your lordships to the specific, my lord, description, my lord. Description of land. I have given the description and boundary description in the north, Nala, my lord, in the south, Tana, Puna, in the east, Kabakbat, and in the west, Nala, my lord. This is the, my lord, the prescribed format. And again, my lord, form for notice of inspections of land, my lord. Next page, my lord, page number 28, sorry, my lord. 28, my lord. This is the, my lord, the format prescribed by the state respondent. Whereas Sri so and so, my lord, so and so, my name is given, my lord, so and so, certificate. In the north, south, my lord, it is given. And whereas, my lord, I'm reading, my lord, just from the, just to get, my lord, clarify the, my lord, that aspect, my lord, how the notice are not given, and where is the, my lord, the provisions for giving the notice to the spouse, my lord. Whereas the EAC, so and so, designations of the so and so hereby. Now, therefore, the following persons are hereby directed to remain mentioned, the above mentioned place on the day and the time specified before which the authority arranged or survey and inspected the land. Malad Sri so and so, Malad persons who is required to be present on such verification, the name has been specifically given, my lord. And there is no, my lord, the provisions for the given, my lord, my lord, separated wife. That cannot be, my lord, there cannot be, my lord. There is no provision, it says. My lord, had it been the case then, my lord, where is the difficulty with serving a notice upon to her? Definitely, my lord, the service will be given to, my lord, service of notice upon should be given to my separated wife. There is no issue, my lord. But where is the provisions for serving the, my lord, notice to her? That is the, my lord, whole problem. And the, my lord, again, notice for written objection, my lord. Page number 23 again, madam. I'm sorry, 29. My lord, these are the, my lord, the requirement which has to be followed I, as a citizen, as a landowner, just I build up and given it to if there is any discrepancies, if there is anything, that can be returned back to me for correction. And or claim an objection, written objection is invited. This is the format, and in format I have built up everything. And NOC, page number 30, no objection certificate.
This page is important one. Because in page 23 onwards, the name has been shown as Tanna Puna. But where is the signature of Tanna Puna?
It is there,
He is not signed. One Tanna Agu is there in page 30. In page 23, it is Tanna Puna. In the south, page 27, it is Tanna Puna.
May I complete,
Yeah.
Here at page 30, there is no name of Tanna Puna. In any case, Tanna Agu has not signed also.
Tana is there.
Tanna Agu. Tanna Agu is and Tanna Puna are different. Tanna is a title. Puna is name. Agu is the name.
my lord, page number 28 again, In the north, Tanna Agu, He is the same person, claims inspection, as per the inspection, he is the same person. And the claim and objection, if at all, object NOC has to be given by the Tanna Agu himself, not other than the Tanna Agu,
Inspection basis.
Tana Agu is there.
Yes, madam. And that has been duly approved by the village authorities. Head Gambura, madam. Page just below same page 30. It is Karaniki Head GB, madam. He has given his signature, and put his seal.
It is there in the order that he has withdrawn this. He said, I thought it was both of you are together, and that is why I signed. I didn't know that both of you are now having this problem. Therefore, I'm withdrawing.
Then we'll do one thing. This matter is fixed today for in regards to maintainability.
Correct.
Suppose hearing the Mr. Patin, if the entire matter is suppose non-maintenance, not maintainable, then it will be disposed of. Otherwise, I'll decide the maintainability issue. If it is suppose maintainable, then we'll hear the matter. When mainly the issue is raised is the maintainability issue.
Correct.
So maintainability issue, he raising those points. As the matter has, the civil dispute is going on regarding this so it is not maintainable at present.
True.
That is the main issue.
Yes,
So we may pass the order if it is at all not maintainable, then definitely entire the decision will go.
Correct.
Or if it is suppose we held that it is maintainable, then matter has to be heard again.
Sure.
Yes.
So so that is the issue.
So
Then
therefore,
apart from that,
so therefore, my prayer is, maintainability, the merit of the case is required to be heard is because, this is something, which errors and the serious discrepancies has been done by the same issuing authority who issued, who is empowered to issue LPC, without following any procedural law, the same has been cancelled. Only on the flimsy ground, Lordship has already seen, for non-service of, non-issuance of notice upon to my separated wife, Because of that reason, can the additional deputy commissioner cancel his own documents, which has been issued in compliance of everything. No, now the question is that now the Lordship has already seen the judgment. I have not seen just what I've gathered from the reading of the senior counsel. I've just taken note of the one thing, that is in respect of the judicial proceedings where the judgment can be reviewed, if at all, there is a provision. We have no quarrel on that, But this is regarding the cancellation of the LPC by own the deputy commissioner, pointing out that, no, you have not done these things, you have not done that things. Because of the reasons, we are cancelling the No, my submission is.
But the same authority had issued.
I just come back to page 27, the application.
So therefore, my lord,
Well,
merit of the case is required to be heard, my lord. It is very much maintainable as because I am raising the point of the, my lord, the crux of the case, my lord, that you can, my lord, the additional deputy commissioner cannot straight away cancel, my lord, the LPC is issued in compliance of the entire things, my lord.
My lord, in page 27, the application, your lordship may kindly.
My lord, maintainability part. Yes, he started everything.
My lord, page 27, my lord, in his application itself, I am enclosing here with the following documents in support of my application.
So therefore,
certificate from Forest Department, 2, certificate from the village council, such and such, 3, sketch map of the land. My lord, nothing is there. These 3 basic documents, as per the guidelines, they is missing.
So this will come at the time of hearing of the final hearing of this matter.
my lord,
So we pass the order on the issue raised by Mr. Patil in regards to
my
maintainability.
lord,
If it is supposed maintainable, then we'll fix a date for hearing.
my lord.
And if it is not at all maintainable, then interim.
My humble,
Yes, that's the end.
my lord, correctly, my lord. My humble submission before lordship is, this is required to be heard on merits of the case, my lord, without raising, my lord, other things, my lord. Again, my lord, just and for the ends of justice, my lord. Otherwise, my lord, if anything is done, my lord, my lord, wrongly by the, my lord, the additional deputy commissioner, my lord, that will seriously prejudice the either of the parties. So therefore, or my lord, if my lord, on merit of the case, if it is heard, my lord, in detail, my lord, everything will be clear. So therefore, my lord, at this stage, my lord, without hearing the, my lord, piecemeal on maintainability part, my lord, for the ends of justice, my lord, the matter may be, my lord, fixed for the.
Yes, what you have already filed your affidavit in opposition. That is in the main, we'll be hearing the main hearing at the time of those will be considered. But in respect of the maintainability issue raised by. In that context, you have nothing to say, suppose. Matter in fact, the main issue, now that is the issue. Suppose if it is not at all maintainable as per so as Mr. Patil, then entire matter will go, no need for hearing for the further marriage. But if it's suppose considered that it is a maintainable, then definitely merit will be hard.
Yes,
So I'll pass the order.
My lord. And my lord, may kindly take note of one thing, my lord. My lord, Mr. Patil, Senior Counsel, my lord, he has not raised, my lord, a particular my lord, objection on maintainability by filing, my lord, affidavit, my lord. Today,
No, my lord, I have filed. I have
my
raised
lord,
this question.
of course, my lord,
filed my
that is, my lord, that is raised in the, my lord, of course, in the same, my
I
lord,
have also,
in the, my lord, the preliminary, my lord, that is also one aspect, my lord.
I have also stated
No,
clearly that.
you're submitting that he has not filed any separate.
Correct, my lord. That is the point, my lord. I
Otherwise,
wanted.
affidavit in opposition, you have already.
Yes.
Most probably, in the affidavit in opposition itself, he raised those points.
Raised, yes, my lord. Separate, my submission is separate.
Yes, separate. It's not there, I think.
Yes. In mains, he has raised, my lord. We are ready. We are ready to reply, my lord, his objection, my lord. So therefore, my lord, my lord, submission is for ends of justice, my lord. We may be given an opportunity to, my lord, present the merits of the case, my lord. That's it. Leave level.
So on the menu.
Obliged,
What wants to do by his name?
What they have submitted.
Needs to be done.
There cannot be more submission than this. Even
Yes.
My lord, if in that case, my lord, I will go by one, my lord. That is one.
Otherwise, you were supposed to, I mean, make submission on the mail.
In their affidavit, they have said, they have justified their cancellation because the party was not, proper party was not given a notice.
Proper party?
The
Who is the
party,
proper?
that is me, was not given, there was a violation of the principle of natural justice.
During issuance of
No,
LPC,
notice.
my lord, notice.
No, that you have saying that. Oh, yes, yes, that will be considered.
Obliged.
Okay.
Leave level.
Yeah, that's it. Yes, sign over. You have already filed today. Then do not go, Mr. Complex, so and so, 1 and 2. And you have already submitted.
Pleadings
Mr.
are
Patil has
completed.
already also submitted.
My lord, pleadings are completed. Only my,
Pleadings are completed.
my lord, only my.
No, it was fixed for hearing only that maternity issue only. Otherwise, almost many things been submitted.
My lord, that was my last submission, my lord, the submission on the last occasion, my lord. The entire matter may be heard, my lord. That was but my lord, the senior counsel is always insisting for the maintainability on raising the matter.
Otherwise, but most part of the matter is going to have.
My lord.
Anyway, we pass the order.
Yes, my lord.
Otherwise, I have a very limited submission.
My lord.
Take hardly 3 minutes on my part.
No,
Let
the first. Yes, my lord. The recess has to be. And my lord,
You have to go by this.
Yeah, no,
You have to go by this.
my lord, as per the order of your lordship, I have to file my lord, the affidavit in reply to the affidavit in opposition filed by the my lord, private respondent.
If your case survives, then only we will file.
Correct, my lord. That is the my lord, the one aspect. True, my lord. Deep level.
We're not supposed to. I didn't now. I don't say. This is also in the admission column or in order column?
Order column.
If it is in the.
My lord, everything
I
is
may not
required,
be
my
in a
lord.
position to hear the matter. Otherwise, if it is order column, then it's okay. What is the, why it is in order column?
Your lordship, in respect of respondent number 3, we have filed, but
Respondent number
4 and 5.
1, 6 is there, na? You have filed 4 and 3 and
1 to 5, your lordship.
1, 2, 5. 1, 2, and 5. 1, 2, and 5, you have already filed.
Yes, 3 has filed, your lordship. 4 and 5 needs to be filed.
No,
Only
you
3
have
or-
filed 1, 2.
1 to
Only
3 will be sufficient for 1 and 2. 1 and 2 and 3. 1, 2, and 3 will be the affidavit of respondent number 3 will be sufficient for 1 and 2 also. Regarding
No,
4
no,
and 5,
yes, but you have already filed affidavit in opposition by respondent number 5.
3, your lordship.
Respondent number 3, yes.
3 has already filed.
Yes,
Yes,
So
yes.
1 and 2 will also rely on
Yes,
2
your lordship.
and 1 and 2. Okay, 1, 2, and 3.
Regarding 4
Now,
and 5, we
4
need some more time, your lordship.
For 4 and 5, you need some total.
Yes,
4 and 5. And 6, who is 6?
This
Six
is
is
a
awaited.
private
Oh,
respondent.
already completed service. na?
No, your lordship. I'm behalf of Mr. K. Tama, learned counsel of this case. Your lordship, we need some more time to file a counter affidavit.
We can do heard Mr. Spencer Kwedibu. Also heard Mr. Y. Diram, the London Government Advocate, appearing on behalf of respondent number 1, 2, and 3. And it is submitted that 3 has already filed their affidavit in opposition, which will be relied by the respondent number 1 and 2. We further he paid time to file the affidavit in opposition on behalf of respondent number 4 and 5. Poster. The respondent number 6, the private respondent had already appeared, and it is submitted by MS so and so, appearing on behalf of the NBS counsel, Mr. K. Tama, that the respondent number 6 will require some more time to file their affidavit in opposition. So for 4 and 5, how many weeks you need?
3 weeks, your lordship.
3 weeks. This is the matter
Lordship,
according to
interim order is there.
interim order was there.
It may be continued.
Interim order will continue till next date of posting. Okay. After 3 weeks.
Much of it.
Yes, what is the position of item number 20?
My lord, they have to respond number 1 to 7 has to file the affidavit. And
1, 2, and 7.
1, 2, and 3 is 1, 2 in government, my lord, and
Your lordship, here also we need some more time, your lordship.
You're for 1, 2, and 3.
No, your lordship, I am for
1, 2.
1 and 2. 2, your
1 and
lordship.
2.
You're for 2.
Yes, your lordship.
3 is standing counsel of
3 standing counsel is there. And 1 for 1 who is appearing? RD.
Your lordship, 1 and 3 will be the standing
By
counsel.
standing
Yes,
counsel.
your lordship.
So 1 and 3 has already filed.
No,
No,
no.
not yet filed. And you are representing 2, you need some more time.
Yes, Your Lordship.
And 4 to 7 is a private respondent.
4 to 7 are private respondent. Whether they are 4 to 7, the
4 to 7, I have,
service is still awaited or it already been
no,
served?
my lord,
Personal service is there.
yes,
Already
already
served.
served through dusty service, and in that regard, affidavit has also been filed.
Also been filed. Any order passed in that regard that the service is already completed 4 to 7? But in the last occasion, on 11/10/2023, there's an order. Affidavit towards completion of dusty service and so, but the affidavit you have already filed, it was not in record.
My lord, last occasion, someone is taken adjournment, ma'am.
Oh.
So I have not given opportunity to mention this aspect, ma'am.
But Mr. Swenson demanded counsel for the petition, and also had Mr. Y. Idam, demanded counsel appearing on behalf of respondent number
2, Your Lordship.
2, and submitted that some more time we required to file their affidavit in opposition. Further, it is submitted by the counsel for the petition that the respondent number 4 to 7 are private respondents, and the service is already completed on respondent number 4 to 7, and in that regard, they have also filed their affidavit after service of the notices through dusty mode. Where is the affidavit in fact? Affidavit 9.
There must be an affidavit.
Oh, yes, yes. Personal service 4, 5, 6, 7. Okay. Affidavit in this statement. You need 2 weeks or
3 weeks, Your Lordship.
at least after 3 weeks. Okay, affidavit.
My lord, there is interim order. Let me
Here also you have interim.
Yes, my lord.
Okay, on the first date of this thing, na?
Uh,
It was
on-
passed on
My lord,
day.
on second, my lord. Second list. On
when it was passed. Was it 10/10?
10, 10, 20,
10
10,
was passed, na?
no, 11, 10, I think.
Yes,
11,
yes,
10.
it's 10. Interim be continued till next date. Okay. Released after 3 weeks, huh? Okay.
Oh, yes.
Item number 31.
Here also, Your Lordship, in respect of respondent number 9, we need some more time.
Respondent 9.
Yes, Your Lordship. May I, Your Lordship, in this case, respondent number 1, 2, 3, 4, 6, and 9 are yet to file the affidavit in opposition. And to the respondent number 4, 7, and 8, we were allowed to take the step through dusty service, and we had filed the affidavit of service on 29th of this month.
So 1
1, 2, 3, 5, 6, and 9.
state is representing 1, 2.
No,
You are representing 1,
only 9, Your Lordship.
only 9.
Yes, Your
Acha.
Lordship.
9, Mr. Y. Ram Likhibu. And
Hello.
Mr. Kamru, you are appearing for
For my lord, the respondent number 5 and 6, my lord.
5 and 6. Have you filed your affidavit?
No, my lord, I am seeking 5 weeks time, my lord, for filing.
5 weeks.
Yes, my lord. My lord is, have seen my lord. Our land department has too many cases, my lord.
No record of giving 5 weeks. Yes, your department is.
Yes, my lord.
This is a peculiarity of the Arunachal Pradesh, I think.
Yes, my lord.
Because land acquisitions are there, thing is
Yes.
there.
That is why, lord, so we are
Yeah,
unable to.
in Assam too, we have some Miadi Patta land and also
Yes.
these are not such kind of acquired land or LPC, etc. Not there. We have the land.
That is
But
why, my
here
lord.
the particular problem is there that they all are,
Yes.
some are acquired, some are LPC granted, some are the donated,
We
these
have,
kind of things are there.
lordship, more than 700 cases, my lord, in this.
Oh.
That's why, my lord. We are-
So you are the only standing counsel
Yes,
looking after all this?
Yes, my lord.
You may make an application everybody already concerned to appoint someone else. Okay, 5 and 6 already got, okay, 4 and 5. So you are for? You have already filed? Not required, okay. 3, Alpha is for 3. 3, 1 and 2 for most probably 1 and 2 is it forest or what?
Union.
Union of India. Mr. Kato was representing the 1 and 2 on earlier date of the. As in I am liquid, 5 weeks time. Will and in regards to the service, is there anyone? Because government side is there and otherwise?
For the private respondent number 4, 7, 8, we have
4,
taken the step through the service and affidavit of service we have filed on 29/5/2024.
for 4, 7 and
8,
these are private, no?
yes, and
4, 7 and 8.
4, 7.
So you serve the notice to Dusty Mode?
Yes, just a moment. We have filed the affidavit of service on 29th
Affidavit
of
of service is already in the record or?
Yes,
Oh,
we have
sorry,
filed,
yes.
yes.
Nagiri copy, it is submitted by so and so. Non-counsel for the petition that they've already issued notice to respond number 4, 7 and 8. na? 4, 7 and 8 to Dusty Mode and the service of the notice in that the affidavit is also been filed in regards to service of notice to the private respondent to Dusty Mode. List accordingly after 5 weeks. Okay, please. And now, if you suppose I want to sell my land, then what is the procedure? Selling of land is not allowed here.
Private property, my lord, that can be sold, my lord. But the government.
Most of the
government allotted land
property are
cannot be sold to anyone.
government property, I think.
My lord. LPC land, lordship, that can be sold, my lord.
That can be sold.
Yes, but the government land, that cannot be.
No, that cannot be, that
Yes.
cannot be. So here is a problem
Yes.
regarding the land management. Okay.
Much okay.
Yes, 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 yes,